তো তুমি বুঝবো কি করে? ভিডিও দেখানো এদিকে না, ওখানে কি এদিকে সুন্দর এখানে
And permission of your lordship.
Yes.
Lordship, these are the two matters which we have filed on 17th of April. It's a criminal appeal, not yet been listed for mentioning a motion event. Lordship, one more request.
Yes.
This item is Constable Raghunandan. This matter is today listed at 74. We are ready with the matter. If your lordship may kindly update the matter, I am ready with the appeal. Tomorrow maybe.
Very well. Just inform the state also.
Very well.
Otherwise, it will be
No, obviously that will be.
Appeal hearings. We intend to whatever appeal hearings you want to do, we'll keep it this week. Because
Very well.
If you take up the appeal, we cannot.
I'm grateful.
That will be
Madam,
easy.
Thank you.
74. Very well.
But I'm praying leave to file a memorandum of appeal with certified copy of the order.
Yes, Mr. Shahara.
Order
Why
has
leave
been
required?
on the law. Fine. Leave because my last day of summer vacation order has been passed. We have applied for it, has not been given, and matter is extremely urgent. Altogether, we are enjoying an interim order.
Leave is
Let it
granted.
appear
Mr.
on
Shahara,
Thursday.
leave is granted.
My lord,
Yes,
let
yes,
it
leave is
appear on
granted.
Thursday.
Yes.
My lord.
It will
Get
appear
to
on
the-
Thursday. Thursday.
I'm much obliged to you. Get full credit.
Acha, very well. This criminal appeal 74. Let it appear. You inform the state. It will appear as specially fixed tomorrow. Then
I'm grateful.
immediately after the applications, we'll put it.
I'm
up.
grateful.
Inform the state.
Lordship.
May I?
Yes, yes.
One MAT for inclusion in the list. It was filed. as-
FAT, MAT. It has been formally admitted.
No, my lord, it was not admitted. It was earlier filed. Thereafter, it has been showing as a defective. My lord, thereafter, it has been out of listed. We are regarding steps for
Defective have cured.
defect. My lord, Section 5 has been found.
Well, give the number, section 5 number also, can number. Well,
Lord, may I
it
be
will appear
permitted
under
to
heading
mention-
can then first.
Lord, may we permit to mention a matter for inclusion in the list, my lord, under the heading bail in connection with appeal?
Yes, yes, please. What is the second slip? For other court? No, this, why two slips?
This is my copy. All right.
Call on the list.
Item number 1.
দেখি কি ব্যাপারটা তুমি মেনশন কেন আছে লেনোড বলছে কি অফিস নোট আছে দেখুন দর্শককে দেখুন সেকেন্ড পেজ কপি আর এইটার কপি নেই এটা বলছে যে মিডিয়েটরের চেঞ্জ চাইছে একটা অর্ডার রেকর্ড কর none appears for the parties at the time of call. So it transpires.
We are for the appeal.
You are for the appellant. You are asking a change of mediator. Why?
Because he is unwell, my lord.
He's unwell. Have you given a notice to the other side? Give a notice to the other side then. We'll take it up day after tomorrow. You can serve by tomorrow. Very well.
We are just file an application before the deal for the change of
Before?
to the office of the legal service. Because for the this application.
No. This can 2 or can 3?
No, already disposed.
No, already this application for the change of mediator. We are
This
not
is only for
for-
change of mediator. Very well. Hello, কেটে দিন. The learned counsel appearing for the appellant submits that due to the physical incapacity of the mediator, comma, the appellant seeks a change of mediator. Push up. The appellant shall serve a notice in that regard to the learned advocate for the respondent and or the respondent directly intimating that the matter shall next be listed on June 10, 2026, under the heading to be mentioned. Give a notice. We'll take it up on day after two. And if you can, please have a talk with the other side's advocate. If you can agree on a mediator, we can name a mediator also. That will be easier for us. Otherwise, we'll appoint somebody.
Item number 2.
My lord, I am on behalf of
Yes.
the applicant. It's a criminal appeal, my lord.
Yes.
The paper book is already ready, my lord, and I'm also ready with the hearing.
Hearing of the appeal.
Yes,
So bail, you are not pressing then bail.
my lord, if your lordship wants to hear the bail application, because earlier I've also done the hearing.
Your Lord friend is appearing for the state. You are, oh, Mr.
My lordship,
Mishra,
in item number 2 and 3, we are
Yes.
yet to receive the paper book from the department. My lords. We will have it and we will do it.
No,
So
it is there with Anuruddha. Vishwas.
Oh, then he hasn't returned it yet.
oh.
The last council who was there who was looking
We'll
into
keep
the
it
matter.
Day after tomorrow, Mr. Mishra?
Day after tomorrow. my
Day
lords.
after tomorrow,
Yes,
because
my
we are.
Both the jail appeal, my lords, I will do before my lordship.
Thank you so much. Thank
Two
you
and
so much
three.
to 2 and 3, because we are confident of your pace in getting yourself prepared. But you have
Not
to
in
get the
criminal
brief
matters.
first.
Not in criminal matters, but yes,
No,
I will
not
do it, my lords, day after tomorrow.
Day after tomorrow, we are keeping it for the
Yes,
time
ma'am.
being.
And just a humble request, my lords,
Yes,
this
yes,
is out
yes.
of turn. There is a matter appearing before my lordship, which is a hearing matter.
Huh.
This one, my lord, is item number 68.
68, yes.
This is regarding the formation of the SIT. Mr. Ghosh is there for the appellant, my lords. This matter also we will do, if my lords permits, we will do it today or tomorrow, my lords. This is the only case in which, my lords, the file has been received
But
by
as
me.
you say, you are ready in this matter.
No, I
You are-
was at.
No, she is in 2 and 3. She is in 2 and
No,
3.
not 20. I'm only in item number.
Oh,
2.
I'm so sorry. She is in 2.
Only item number.
Lordship, in the matter, I.
Three.
present the High Court administration.
2 and 3.
No, no.
That.
Acha.
SIT.
He is talking about
The
the
SIT matter.
68.
Rajeshri.
SIT matter, very well. Then SIT matter will keep it as specially fixed on Thursday. Thursday. So that
Tomorrow,
all of
tomorrow, first
tomorrow.
matter. First
Can
matter.
the other side get ready? We don't know who is up.
Oh, they have already argued the matter once. It was
Oh.
interim was passed by my lordship. It has went up to the Supreme Court. The Supreme Court said that the interim is stayed and the hearing will happen de novo without being getting influenced by
Very
the
well. This will
interim.
appear as to be mentioned, specially fixed tomorrow. Item 68 will appear as specially fixed tomorrow.
Yes,
Let it note করো। And 2 and 3, 2 we are passing an order. Learned counsel for the appellant submits that the appeal is otherwise ready for hearing. Push up. Mr. Mishra, sorry.
My submission,
What's
lord,
your
says,
designation?
Assistant Additional Advocate General, Triple AG.
Learned-
My submission, lord, says that the erstwhile counsel who were there, they haven't returned the paper book yet.
Learned,
If I am able to collect it today, day after tomorrow. we will do
Learned
it.
Triple AG submits that since the brief has not been returned by the erstwhile learned advocate appearing for the state as yet, some time may be given. Full stop. Accordingly, let the matter be posted under the heading specially fixed matters on this will fix on Thursday then,
My lordship.
on June 11, 2026.
It's a legal aid matter, my lord.
Very well.
And he's in custody for the last 5 years.
Absolutely, we'll
And
take
it's a
up.
very good case.
In all jail appeals, I will appear for the state.
Well, 3 also call 3 call for 3.
Item number 3.
My lord, I am for the petition in item number 3, my lord.
The appeal is ready for hearing in this
Yes,
matter
my
also.
lord.
So same order in 3
My
also.
lord, I am also ready with this matter.
So Mr. Mishra, same order in 3.
হ্যাঁ পেপার বুক আছে তো
আমার কাছেও আছে।
Yes, yes, I
I
think
will-
that,
I will
that
collect it
that
from
will
them.
be easier, Mr.
Instead of waiting for the
Instead of waiting
erstwhile
for them,
counsel,
yes.
my lordship, I will do.
This also same order. 2 and 3
I will
actions
do
করে দাও, Dipankar. 2 and 3 same order. This will also appear as specially fixed on Thursday.
Yes, my lord.
Thank
I will
you.
do both of these.
You just please hand over your extra copies to Mr. Mishra.
I
So
do
that he
not
can
have
get-
any extra
My
copy,
lord,
but I
same-
can.
Take out photocopies and
Yes, my lord, that I can do.
legal aid matter through
Legal aid
DLSA.
My matter
So
is not,
DLSA has sufficient funds.
Kolkata High Court Authority, ma'am. Legal.
Whichever authority, I mean, they ask for money from the authority to get photocopies for.
আচ্ছা, কপি করে দিয়ে দেবে বলছে। আচ্ছা, ঠিক আছে।
Thank you. Yes.
I'm prepared.
my matter is not from legal aid, my lord. It's
Then you prepare
my
yourself.
lord, certainly.
একটু free হয়ে গেল,
একটু pen টা নাও না।
I'm out.
স্পেশাল ফিক্স গুলো দীপঙ্কর খেয়াল রেখো, হ্যাঁ, দিন না গুলিয়ে যায় কোনটা কবে থাকবে। নট টুডে না থাকলে নট, প্রথম দিনটা ছেড়ে।
Second number 5.
Same.
Second number 6.
My lord, in item number 6, I'm praying for short passover.
Very good. Possible.
Second number 7.
Well, I'm praying for not.
Good. Not.
The difficulty is that the state councils, we do not know who are the state councils.
Yes, we understand. We understand that fully. Difficulty for the state also. If you can locate this, inform them.
Even we do not know who is in charge of it.
No, you can approach the PP office. Somebody has been appointed as PP. Who is the PP now here?
Even.
Mr. Muni-
My lords, we were with the opinion that if your lordship kindly could have ice breaking so that we could able to know that who are the persons.
No, you can approach the council who are appearing for
I
this.
have specifically intimated they are not interested to come to the court session. They are not able to face us. Simple thing.
Who is not able to fit?
The persons who are selected this time, the state.
No, they don't have the briefs probably. They have not been handed over most of
They don't.
We are,
Does they don't
let them
understand?
be appear before your lordships. We could have been hand over the briefs.
You approach the gentleman who is sitting there behind
Yes.
silently. This gentleman, the first row.
Jagriti.
Approach him, he'll take care of this.
Jagriti.
My lord, so far my knowledge goes, there is a specific notification which declares who is supposed to be holding which post for the state. So the council should approach them accordingly. If the brief is there is a
Approach in
refusal-
writing. Approach in writing.
There is an approach in writing. If the refusal comes in writing, court will take action.
Absolutely. Absolutely.
That one is-
Fair enough. Yes. Right.
Second number 8.
Lordships, I am for deputy.
Yes. But none is appearing for the state.
State. So I have already handed over the copies earlier.
We'll just give one more day to the state because they are probably handicapped, most of them.
Day after tomorrow.
Day after tomorrow, very well. Although the appellant is represented through counsel, none appears for the state at the time of call. Let the matter stand adjourned till June 10, 2026, when it will be listed under the same heading. Push up. The learned advocate appearing for the appellant is requested to intimate the pendency of the matter to the learned advocate for the state in the meantime. Please just take information and intimate in writing that it's appearing.
Second number 9.
Lordship, in item number 9, I am praying for not this week. Lordship.
Why not this week? You are
Lordship, Advocate Shototru Lahiri will appear for this.
for the appellant.
Yes, Lordship, he will do it physically before your Lordship next week.
On the prayer of the appellant, let the matter stand adjourned till June 15, 2026.
Second number 10.
Lordship, I'm for the appellant, Lordship. Lordship, this is a bail application in connection with the appeal. We have served the copies to the state.
You have served.
We have served.
Although the appellant is represented through counsel, none appears for the state at the time of call. First of all, let the matter be listed on June 10, 2026 under the same heading. First of the learned advocate for the appellant is requested to intimate in writing about the pendency of the matter to his counterpart appearing on behalf of the state in the meantime.
Obliged, my lord.
Yes.
Number 11.
11, I am for
Yes.
the petitioner.
Right.
So there is a limitation of 176 days.
Limitation, what is the delay?
Delay for filing of the appeal.
What is the delay? 271 days. On the last occasion, it was taken up but could not be heard because of the
Yes,
state.
the state was not there. That's why.
Give a notice to the PP office or wherever.
Already served the notice.
What does the notice say? देखिए. This was before the regime change. No, serve again. The receipt filed today be kept on record. Push up. Despite service, none appears for the state. Push up. However, we take judicial notice of the fact that in the meantime there has been a change of the panel, and accordingly the learned advocate for the appellant is requested to serve a fresh notice about the pendency of the matter to the present, to the present learned public prosecutor, indicating that the matter shall next be listed under the same heading on June 10, 2026. Give your appearance. Yes. Not today. 11, 12 same. That is 11, 12 same order.
May I please your lordship?
Yes, please.
Lordship, after change of the regime, I have served all the copies.
Ah.
And today's matter is pending for the CRAN 1, that is continuation of delay to admit the appeal, CRADB 30 of 26. Lordship, it's a legal aid matter, and due to the process, there was a delay, and 212 days was the delay. I have mentioned it at page number 5.
Have you got a copy of the receipt you have?
Lordship,
Please give that, we'll keep that on.
Lordship.
You have also filed an application for suspension of sentence or bail.
Lordship, but after this only I can file, after admission. Dada. Lordship, it's a 25th May. 25th May. Let it be come up tomorrow then? Better.
Inform whoever is there.
Oh, okay. In
Just not-
writing, I'll do that. today
Yes.
itself.
Not to করেছে।
Lordship, similar order for the next.
Pardon?
14.
14
Similar
also
order.
14 টা call. Same.
Similar order. Grateful.
We're not passing any order, we're just
Very
making it
well,
not.
very well, tomorrow. Now.
পাস ওভার একটা ম্যাটার ছিল না? আচ্ছা একটু পরে ডাকো দেখি ম্যানামাস অ্যাপ্লিকেশন
Number 15.
In this case, my lord, mandamus matter, my lord. Additional government pleader requested me to inform before lordship. The new panel has come before lordship. The mandamus on all mandamus matter, my lord, being not this week, my lord.
Not this week.
Yes, your lordship. AGP has intimated, requested me to. He instructed me whatever your lordship.
No, suppose the next matter is Chief Commissioner of Customs. They're also
No, that matter, no, don't matter. West Bengal, state of West Bengal is party, my lord.
Well, there are three sets of respondents in mandamus appeals. One is majority is the state, some part is with the GST, CGST,
other authorities, yes.
and a handful with the union.
So we'll call on one by one and then,
That is
Yes, sir.
better, Bharat.
Yes,
That
sir.
will be
Yes,
We'll be able to locate which one belongs to whom.
right.
yes, your lord.
So item 15 হচ্ছে on the prayer of the state, let the matter stand adjourned till June 15, 2026. Please be present, keep somebody and ask for adjournment when it is called.
Item number 16.
Lordship, item number 16, Lordship, Mr. Vikramaditya Ghosh is appearing this matter.
Mr.?
Vikramaditya Ghosh is appearing
Yes.
this matter. He is in the vacation bench of Supreme Court, Lordship. So kindly fix the matter tomorrow, Lordship. One day accommodation, Lordship.
But we are making not today only.
Grateful, Lordship.
My lord, in item number 16, I'm not the respondent, my lord.
Yes, appellant has sought for a day's time, so we are taking it up tomorrow.
Kindly, my lord,
Right.
kindly fix it day after tomorrow, my lord.
Day after tomorrow will suit you.
Yes, my lord, my lord.
Very well. তাহলে ওটা day after tomorrow দিয়ে দিও. Not today, not tomorrow. Day after.
Grateful, my lord. Grateful.
Thank you. Thank you.
My lordship,
Sir.
extremely apology. Item number 16, maybe can we fix on Thursday? The respondent,
No, we have kept it day after tomorrow. Day after tomorrow. Somebody appeared.
but
Yes.
Yes.
Vishwa, better.
Item number 17. Lordship, for the appellant, in this matter, Mr. Pimandu Banerjee is appearing. He is to appear virtually.
My lordship,
He will be coming on the next. Kindly fixes this matter on the next.
Use the microphone so that somebody is there.
my lordship,
Lord, I'm free.
responded.
You are for the respondent. You are appearing in
lordship-
person.
Yes, my lordship, I am appearing in person. I am appeared
this matter for the respondent, and in the writ petition, I am the petitioner, my lordship.
আমার কাছে ফাইল আছে।
All right. So when are you asking for it to be?
Next week, first day, my lord.
You are-
Monday.
I have for the state next week, my lord.
State is asking for next week, Ms. Bonik, so we are keeping it next week, 15. Very.
What are you representing?
Obliged, my lord.
On the prayer of the state, comma, let the matter stand adjourned till June 15, 2026.
Lord, sir, I am appearing in this matter, Lord's item 17. My lordship can have it any day. The file is there with me.
17.
17 minutes, 17.
17 just now, adjournment was.
Sir, is there.
I am for the appellant. Yeah, for the state.
No, you are asking for adjournment.
I am for
Till next week.
till next week.
তাহলে একটা order record করে on the prayer of the appellant, Mr. will keep it.
We have the file in this case.
Very good. On the prayer of the appellant, let the matter stand adjourned till June 15, 2026, on the prayer of the appellant.
Obliged, my lord.
Thank you. Please come back on fifth.
Item number 18. Item 18, I am paying for not today, lordship.
Not today.
Item number 19.
Item number 19, I am appearing for the Siliguri Municipal Corporation.
My lord, I am for the appellant.
So
My
you can
lord,
take up.
this is an appeal, my lord. In previous order, my lord, there was a direction to serve upon the private respondents, my lord. They did not receive it, my lord. So there was a direction to serve it to the advocate who appeared for the private respondents. My lord, I have served them, my lord, but my affidavit is being affirmed. I will file it
You
in
are
the
appealing for
course
the
of
private.
the
We are appealing for the Siliguri Municipal Corporation.
My lord, in this case, my lord, we have filed an appeal without any stay application, my lord. To consider the appeal, my lord, I need to prepare a formal paper book.
This is item 18,
19.
19. The can 1, what is can 1?
Section 5.
Section 5 application.
No, mine is within that.
19 is Sanjay Mojumdar.
Yes, my lord.
So can 1, there is a can 1, section 5 is there. You have to move that first.
My lord, the order was passed on 27th of November 2025.
Not so long ago.
My lord, there is a short delay, my lord, because the respondent is an authority. He is working under the CGST Assam.
Now, has the private respondent received?
My lord, the advocate has received, my lord, I'm getting the.
We'll grant you leave to file it during the course of the day. Affidavit of service, we are taking up the section 5 now.
Yes.
The file. What is the reason for the delay?
My lord, the petitioner, he is an employee under the state government, my lord. He resides in Assam. So there was some delay in coordination and he coming to this honorable court for affirmation of the appeal, my lord. A can application. For this reason, my lord, there was some delay and there was an vacation and other things, my lord.
We are allowing the section 5, we are keeping it on. So the appeal, you have to prepare paperbooks and usual. You're not asking for any.
Not stay, no, there is
There is
no scope for
of
stay.
any. Well, so we are allowing the section 5 and directing them to prepare paperbooks. Very well. Despite service, none appears for the private respondent, comma, although the appellant and the Siliguri Municipal Corporation are represented through counsel. Full stop. On the prayer of the learned advocate for the appellant, comma, leave is granted to the appellant to file the affidavit of service with regard to service having been effected on the private respondent during the course of the day. So next para, upon a perusal of the averments made in can 1 of 2026, comma, the court is satisfied that sufficient reason for the delay in filing the appeal has been made out. Accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring MAT 30 of 2026. The appeal will now be heard on the grounds taken in the memorandum thereof. The appellant shall prepare and file the requisite number of informal paperbooks within 4 weeks.
2 weeks, man.
Within a fortnight from date. And serve an advance copy thereof on the learned advocate for the Siliguri Municipal Corporation as well as on the private respondent directly. And file a receipt in that regard on the returnable date. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My affidavit. It's fine.
But we have already recorded that. This is that private respondent.
Yes, ma'am.
Nina, affidavit take them. Give it to him? Yes. What a ঢুকিয়ে না বাবু শাহজাহানকে দীপঙ্করটা
Item number 20.
My lordship, item number 20, I am for the respondent.
Lord,
Opposition.
Lord, I appear on
We
behalf
suppose
of
you are
the,
appearing.
my lord, on behalf of the appellant.
Appellant.
My lordship,
we can take it up now. What is this, opposition?
Opposition and my lordship, actually the senior counsel is not there.
Use the microphone so that Mr. Bose can also hear. Use the microphone.
My lordship, the senior counsel is out of station, therefore I pray for 2 days at a time, my lordship.
Today or 2 days?
2 days.
2 days. Yes, Mr. Bose, what about that?
Kindly takes it up on Wednesday.
Acha, very well. And they're using an affidavit in opposition. Would you like to use a reply to that? You are not
No, my
aware
lord,
of that?
I've already served upon this.
Yes, my lord, I don't think any reply would be required, my lord. This is only for the purpose of, my lord, interim release under section 129 of the CGST Act. My lord, this is covered by 2 division bench judgments of this honorable court. So I don't think, my lord, any reply would be necessary.
We'll
at this
take on record the affidavit in opposition. We'll record that your submission that reply may not be necessary. We will take it up on day after tomorrow.
My lord.
My lordship, Thursday, my lord.
My lord, kindly
Thursday. He's
keep
asking for
Thursday, my
Thursday.
lord.
Very well, Thursday.
Yes, Mr. Deborman also appeared. Well, Thursday.
So, my lord,
You are for?
I was attending 21.
I'm for the respondent, my lord.
My lord, in this
Respondent.
matter,
CGST
I
authority.
This is 20.
20.
This is 20, Mr. Deborman. 20.
sorry.
20 তে order record করুন একটা যে on the prayer of the respondent the matter is adjourned till June 11 2026. First of the affidavit in opposition filed today be kept on record. First of learned senior counsel appearing for the appellant submits that in view of the law governing the field, a reply may not be necessary. First of accordingly the matter shall be taken up on the returnable date, that is on June 11 2026.
Grateful, my lord.
Thanks. Good. Thank you.
Grateful, my lord.
21 call. Please give your name. 21, Mr. Deborman, you are for the
yes,
respondent.
I am appealing for the, my lord, appealance, my lord. This appeal was heard by your
Lordship,
lordship,
I'm with
sitting
you.
with my lord, Honorable Justice Prosenjit বিশ্বাস on 30th July 2024.
Oh, then the other division bench has to take it up.
No.
I was a part.
The appeal, yes, your lordship sitting in division bench with Honorable Justice Prosenjit বিশ্বাস had this matter on 30th July
Achha.
2024. Your lordship have
Right.
specific issues on which this appeal would be heard.
Right.
That is at page 2 of that judgment and per book point my lord, paragraph 4. But I am not interested to see the other side is acting or not, but we have served again. The paper.
Lordship,
We have served
You are appearing for the other side.
in this matter, Mr. Kunaljit Bhattacharya appearing this matter. Now he is appointed as an additional government pleader, Your Lordship. Praying for not this week, Your Lordship.
So somebody else will be engaged.
Yes, Your Lordship.
Mr. Deborman, it's submitted that the learned counsel appearing for the state respondent is now the. So take it up next week?
If any specific date for that, I will go personally.
Very well. No difficulty. We are
Monday?
keeping it on June 16th then. June 16th. Monday we have fixed many matters. So
Okay.
16th June is Tuesday. Very.
Tuesday, Lord. Lord,
An
I'll get
adjournment is sought. Thank you. An
No,
adjournment is
plus
sought
I-
on behalf of the respondent. Respondent, first up, let the matter stand adjourned till June 16, 2026.
Grateful, Your Lordship.
Thank you. Mr. Deborman, 16 June. Tuesday.
Lordship. I get put up.
Thank you. Yes. Thanks. Yes.
Item number 22.
Yes, Lordship. I am for the private respondent in this case.
My lords, item number 22, I'm for the appellants. I'm led by senior advocate Mr. Amalesh Rai. My lords, I'm praying that kindly matter be fixed on Thursday, my lords. Some personal difficulty, he could not appear before your lordships.
Lordship, in this matter, there is a direction to prepare the index because on the consent of the.
They were to prepare the index.
Yes,
Yes,
Lordship.
My lords, the index is ready, my lords. We'll serve it in the meantime, my lords.
Well, on the prayer of the appellant, let the matter stand adjourned till June 11, 2026. Full stop. In the meantime, a copy of the index shall be served by the learned advocate for the appellant on the respondent's advocates as per previous direction. Thank you. Give your respective names with who you are appearing for and the item number. Item 22, who is appearing? Oh, 22 holo to. Dipankar Dako.
Item number 23.
23, my lords, I'm for the appellant, my lords. My lord, this is a mandamus appeal, my lords.
What is the defect?
Defect was with regards to the delay, my lords. The delay is, since then it has been condoned.
It has been condoned.
Yes, my lord.
What is Can 2?
Can do the stay application.
There is an appeal against?
Appeal
Mr. Mujumdar, you are appealing.
Lordship.
Please take your seat, we'll just hear it. Yes.
No, a very short matter.
The order passed by the honorable single judge, my lord.
Let us see the order first.
The certified copy is annexed.
So Mujumdar appears to be confident. So we are primarily with you. Let us check the memo. Yes.
No matter, I am confident the matter is short, not with the merit.
Mr. Mujumdar, take your seat, we'll just go through that. Yes, please place your case.
Yes, my lord. So, my lords, initially the petitioner had participated in the recruitment process to the post of Constable GD in the Central Armed Police Forces, CAPFs, 2025, my lords. After initially clearing the earlier stages, which was the
Take the microphone a bit closer. Yes.
after clearing the earlier stages, my lords, which
Yes.
was the computer-based examination, the physical standard test and physical efficiency test, the petitioner, the admit card for the medical examination was issued in favor of the petitioner, my lords. The document verification, he was found cleared, my lords. However, with regard to the detailed medical examination, the petitioner was declared as medically unfit on the ground of 1 second, please. On the ground of severe skin infection in perineum and genital area. That your lordship will find at page 119 of the stay application, my lords. So being aggrieved by this, the appellant preferred a review medical examination for the review medical board, which was subsequently held on the next day, immediately on the next day, my lords. Now, what happened in the review medical examination kindly considers how it was conducted, my lords. On the next day of the review medical examination, the appellant was directly taken by the BSF personnel to one government hospital in Kuch Bihar town, my lords, to obtain specialist opinion before the dermatologist of that hospital, my lords. The dermatologist, simply on the basis of visual inspection, my lords, no lab verification, no confirmatory tests were conducted. He diagnosed the petitioner as having this condition by the name of tinea cruris, my lords.
That is different from the initial diagnosis.
The initial is severe skin infection. Simply.
It was vague. So he specified what is the infection.
Yeah, well, he basically said that it may be the same, my lords. It is not specified. It
Anyway,
is tinea
right.
cruris,
So
basically.
it pertains to the skin.
It pertains to skin.
Well, yes.
That your lordship will find at page 121 my lords, of the stay app. If your lordship shall-
fungal infection and other
Yes,
things.
if your lordship shall see at the remarks, my lords, it has
Mhm.
been written that it is a curable and a non-communicable condition as well, my lords. Lordship. So now, my lords, what happened subsequently is, after obtaining the specialist report, the appellant was taken back to the review medical examination, wherein the review medical board, without conducting any, simply on the basis of visual inspection of the
Page 121 is the review report.
No, my lords, 121 is the specialist.
Initial. Or
Is the-
specialist.
Yes, the dermatologist report.
The first one.
In the review medical report, my lords. The first one is your lordship will find it at page 119. 119, my lords.
So this was the review result, 121.
120 is the review report. It is the same as the specialist opinion. What they have done, they have basically copied. They did not conduct any confirmatory tests to confirm the diagnosis of the specialist. They simply copied the findings of the dermatologist, but only to the extent of that the appellant suffered from tinea cruris, my lords. However, what they have done is they have willfully chosen to ignore the remarks of the dermatologist that the said condition was curable and non-communicable.
What is the chronology? When was this 121 report given? At the first instance?
No.
First instance, he was examined.
By
This
the-
page 119 report was given.
That is direct medical examination.
Very well. Then there was a
On the
review.
next day, the review medical examination was supposed to be conducted.
Huh.
How it was conducted was, he was first directly taken by the BSF personnel for specialist opinion.
So you say page 120 was issued without taking note of 121.
No, it was done.
Simultaneously.
Yes, my lord, simultaneously, as in like First
No, no,
121 was
120,
conducted.
120.
First
report.
121 was conducted.
Huh.
They obtained the report. Then the appellant was taken with.
So that
the
was
review-
taken into consideration in issuing 120.
Yes, my lords, but they have willfully chosen to ignore the.
Why should
therapeutic-
they have a vendetta against you? Why should they willfully
No,
do
my
it?
lord. I-
You are
I-
just as similar to some other person. I mean,
No, but they.
why
also
should
have
they
considered-
have a particular vendetta against you?
No, well, it is constituting as excessive and disproportionate, my lords. I have a judgment passed by the Delhi High Court, my lords, in this regards. If I may please it, my lord.
Curable and non-communicable, you are stressing on that.
Yes, my lord.
What is the, I mean, was there a formal communication to you finally?
Yes, my lords. Oh,
Where is that?
one second, my lord.
Page 123
Page
also you may,
125, my lords.
so 123 also you may want to rely on, no fungal element seen and all.
Page 122, kindly, my lords, kindly comes to page.
No
122.
obvious skin lesion.
Yes, subsequent to the being declared.
That's from a government hospital.
Yes, the petitioner on his own accord went to
But
examine,
BSF is a central force.
went to get examined on his own accord before a government hospital and a private hospital.
That we cannot say overrides the BSF.
That cannot, my lords, but it corroborates, my lords. Kindly appreciates the corroborative value of that. It corroborates that the petitioner's condition was curable and non-communicable.
Wouldn't it be going a bit too, I mean, wouldn't it be excessive for the court to enter into this factual analysis of
Yes,
the,
ma'am, I have a
because they have
judgment
assessed
passed-
in their own way.
I have a judgment passed by the Delhi High Court, my lords, which deals with.
Did you cite it before the learned single judge?
I did not.
It would be appropriate to cite it before the learned single judge.
I did not.
Justice Kant was there. Anyway, let us see. Gorang to Delhi থেকে এসেছে। One copy?
No, my lord, I have.
You have to give a copy to Mr. Mojumdar also, otherwise don't have extra copies. Otherwise, how would he look into it?
My lords, his judgment has.
What is the relevant paragraph? Let us see.
Yes, my lords. The
Any
judgment
particular-
has categorically laid down the conditions in which the court can enter into the merits of
Show
this
us.
case, my lords. Kindly comes to page 47, my lords, internal page 47.
Tolerance. Yes.
Page 47.
We have to give a copy to Mr. Mojumdar.
I do not have an extra copy.
Let us see if we reject it right now, then we won't direct you to give a copy. If we are inclined in your favor, then we'll give you. Yes. Principles that apply.
Page 48 would be more appropriate, my lords.
Mhm.
Page 48, para 4, my lords. Situations in which a court can legitimately interfere with the final outcome of the examination of the candidate by the medical board or the review medical board are limited but well defined. Some of these may be enumerated as under. And in page 52, my lords, point number 6, the aspect of curability has been dealt with, my lords.
So it is circumscribed by the writer that if the condition is itself specified in the applicable rules as one,
Yes, my lords.
which by its very existence rendered unfit,
Yes.
then curability takes a back seat. But in your case, I mean, where do you get those things?
Yes, at this juncture, it would be prudent to place, my lords.
What
the
is this?
guidelines, the guidelines, my lord, the applicable guideline.
This also you don't have a copy for him.
I can give him, my lords. I can give him. I'm sorry.
Should have been placed before the learned single judge then.
No, these were placed, my lord. These were placed.
And us? Any particular guideline which you want us to look into?
Yes, my lords. Internal page 7, my lord. Internal page 7 of the guidelines, where the general grounds for rejection has been stipulated, my lords.
Yes.
If your lordship shall look, the only thing that pertains to skin would be
Yes.
at point number 19, my lords. Chronic skin disease like vitiligo, leprosy.
So chronic is the highlighted.
Yes, chronic. Mine is
Non-chronic.
communicable and curable.
Non-communicable curable does not take it out of chronic.
No, chronic would mean it would be subsisting for a long time, my lords. If your lordship, I showed your lordship that the reports which
Examples are also given here.
yes, which the petition.
Chronic extensive fungal dermatitis is the closest which can,
Yes.
but that's not the diagnosis.
But that is chronic, my lord.
Rather, it's written curable and
Yes, yes. And this has been corroborated by the fact that I obtained reports from the government hospital and private hospital just 1 week after, my lords, wherein it has been shown that there is no.
you are still within the eligible age.
This was my last attempt, my lords. That is why, my lords.
No, but your last attempt you can understand. Suppose if it is reopened before hearing them, are you still eligible by age?
Yes, my lords.
Let us see the learned single judge's order.
Yes.
So you are sitting in appeal, you have to be cautious on that also.
Very well.
That curable and non-curable, non-communicable was issued by the government, your private
Yes, my
thing,
lords. The specialist,
not by them, not by their specialist.
their specialist.
That was their specialist.
Yes. Yes, I was referred, kindly come.
Yes,
my
yes,
lords. Why
yes,
not?
probably.
I was referred by them, my lords. These are facts, my lords.
Maybe fair, but where is the result?
Page 121, we are saying. That is Department of Health and Family Welfare, Government of West Bengal.
Yes.
There cannot be any referral because the rule says there will be a medical examination direct and thereafter a review of the petitioner.
Very unlikely that the BSF will refer to the Government of West Bengal.
No, my lords.
And there is
I
no
was
rule
referred
that
by
Show
them.
us.
I was referred, my lords.
Where do you find it?
I was referred to the MJN hospital, Maharaj Jitendra Narayan. Thereafter, my lords, kindly see the two diagnosis.
My lord, first let him place
It is the same,
referral.
my lords.
No, let him, he'll do it.
This,
Don't fluster him.
these points were not raised, my lords. Now he's saying.
You never.
You also never resist, fine. That's the difficulty. Because we are hearing new things which you were not before the learned single judge, apparently.
There is no talk.
Anyway, we're not shutting you out, but please show us that it was referred to them. As I ask your learned friend to find out in the meantime, and in the meantime, let us see the judgment of the learned single judge.
Yes, my lord.
And you please find out from, you ask your learned friend in the meantime to find out the referral fee. We'll come back to that and let us continue with the judgment of the learned single
My
judge,
lords.
so that no time is wasted.
Before lot takes from paragraph 9 of the judgment where the learned judge.
Yes, we are at para 8, so in any event, we are reaching 9.
My lords, kindly comes to page 120. It has been written, my lords. MJN hospital diagnosed. Written.
तो किस तारीख तुम क्या एमजेएन में किस तारीख रेफरल हो रहा है?
It has been stated.
रिकॉर्ड क्या ओपिनियन?
Mr. Mujumdar, please don't. Please don't. We deprecate this. Sorry. He's a pretty junior member of the bar. You are so senior. Please don't. একটা হচ্ছে সিভিয়ার স্কেল ইন্সপেকশন, সেকেন্ড হচ্ছে এখানে বললো যে পেজ 5 এ ইন্টারনাল যদি কিউরেবল এন্ড নন কমিউনিকেবল যদি অ্যাকসেপ্টেড হয়, ক্যানট বি ইটসেলফ রেন্ডার দ্য ডিসিশন অফ দ্য মেডিকেল বোর্ড আরবিট্রারি, স্ট্যান্ডার্ড অফ মেডিকেল প্র্যাকটিস ফর রিক্রুটমেন্ট আননেসেসারিলি স্ট্রিংজেন্ট। স্ট্যান্ডার্ড গাইডলাইন দেখাচ্ছে, গাইডলাইন দেখাচ্ছে যেটা অনেক নিচে। তার নেক্সট পেজে বলছে গৌরাঙ্গ যে possibility of reoccurrence which is perverse. The possibility of reoccurrence is what ওখানে কোথাও লেখা নেই। সিভিয়ার আছে না? হ্যাঁ আছে, এটাতে আছে। Which page is the reference?
Page 120, my lord.
What's your name, please? Your
Ved Rai.
right. Yes, Mr. Rai. Which page?
Page 120, my lords. If your lordship will look at below the date, my lords, it has been written that the opinion of the dermatologist from MJN Hospital diagnosed as a case of TC, tinea cruris.
So that was considered well.
Yes, it was. They had referred me to that hospital, my lords, for specialist opinion.
The word severe has been repeated in both these.
My lords, I'm simply praying that a medical examination be conducted again, my lords. That opportunity could be granted, my lord. And if he is found unfit, then so be it, my lords. Or if he is found fit, then let it be considered. In such circumstances, my lords, kindly. Supreme Court of India. As I have another judgment as well, passed by the Honorable Supreme Court, my lords. My lords, in this.
Give copies of whatever judgment you are setting, give copies to your other side.
At page 2, my lords.
That was DNS.
No.
Debated Nizar said.
The principle would be the owing, kindly at page 2, my lords, owing to the remedial character, nature of the condition, my lords, the writ petition has been allowed by the Honorable Court.
Let us hear else. Yes, please.
Now the appellant is coming up before this honorable court and telling what should be, which could be. First of all, before the honorable writ court, they failed to make out any case. My lord will see from paragraph 9 onwards. In the impugned order, there was, first of all, my lord, the writ court will enter into a judicial review in an administrative decision if there is arbitrariness, lack of fairness, lack of reasonableness, Natural justice has been violated. My lord, the honorable single judge did not find any iota of those to interfere with the order passed by the medical board in the writ petition. My lord, kindly take the writ petition. Now, I am a little confused to understand that what is his challenge. My lord will see the 3 medical reports referred by the appellant to your lordships of similar nature. Now, out of 3, the 3rd one favors me. So that is sacrosanct. Everything has been done. Every word of Bible has been adhered to. But the report from the MGM hospital does not disclose whatever tests were done. Just because it favors the appellant. So he is saying, no, it is okay. The nature is same. And my lord, on page 120, the opinion of the MGM hospital was considered by the review medical board, because your lordship will find at page 120, I differ with my learned friend, it is opinion of the dermatologist.
He placed that. He says that was considered. But it is contrary to that, because if that was considered, that says curable and non-communicable.
My lord,
so that's perversity.
My lord, let us agree. There are 3 panel of experts. All doctors are expert in the field of diagnosis and finding out cure.
Yes.
Of the disease, whatever it is. So 2 panels says no. A 3rd panel, which has got no statutory sanctity.
3rd panel meaning the last
MGM.
one. That we are not relying on so much. Page 122 we are not relying on. The subsequent report obtained by him.
Yes. No, my lord. 121 is the report obtained by him.
121 was relied on by your board.
No, my lord. He placed it before the board.
But that was considered.
No.
My lord.
No, my lord. This was report. I was referred by
opinion
by the
of
DSM.
Where do you get that you are referred? Do you have not?
Opinion of the dermatology from MGN hospital diagnosed a case of TC.
Yes, so
and the date is 21st.
That was used to corroborate this thing. That report was used to corroborate the review committee's report.
My lord, that report was obtained by him without any.
Maybe, but can you say that after having considered that report and relying on that?
No, my lord, we did not find it proper to take the conclusion into consideration.
See,
so first of all, my lord,
yes,
my lord will kindly appreciate
yes.
There is a medical board and a review medical board.
But everything what the medical board does is not sacrosanct just because they are experts.
No, my lord.
We have to look
but
into
we have
what
to then,
did.
my lord, then we have to delve into the domain of experts and find out where they lacked.
Without doing that, Mr. Mujumdar, we are making it very clear to 2 things. One is that the judgment of the Honorable Supreme Court says it's remedial and not permanent character, which is a consideration, because suppose I have some temporary something. So if on the date of that examination, that temporary thing was there, if it's remedial in character,
my lord,
that cannot.
Absolutely, I understand what your lordship say.
Yes.
My lord, now let us take the particular disease. It needs constant medical treatment.
But these are, Mr. Mujumdar,
my lord, I have not finished, my lord. Just,
beyond the record.
No, my lord, just not the beyond the records. I can place medical journals before your lordship, the authentic medical.
That has to appear from the report itself, but the review committee report itself.
Nature of the. Why I am telling this? Because this person will have to undergo a rigorous training, a bone-breaking training.
Yes.
During that, he will get no medical assistance.
No, we understand that fully.
So a person who is suffering from a disease cannot be allowed to take part in the training. Let him get himself cured first.
You're right, but your guideline says if it's of a chronic nature. There is no reflection in any of the reports that it's of a chronic nature.
Given? Just see the area.
Yes.
Severe skin infection on the perineum of the genital area.
Yes.
So, my lord, we cannot allow this person to go into the training.
That can happen to anybody, Mr.
Yes, my lord.
That's very common.
Very common. But let him get cured.
He has been cured, my lord.
He is cured by the next report. It seems cured.
No, that is a curable, but that is not the report. Doesn't say he is cured.
Kindly comes to page 123 and 124. Just 1 week.
Yes, page 122. If you come, Mr. Mujumdar, between 5 days it was seen that it was cured.
Yes.
My lord, this is a report obtained by the petitioner.
Understood.
Yes.
But now, my lord, if there is a statutory framework, why will the writ court suddenly depart from the statutory framework and direct something to be done?
We are only operating within the statutory
framework.
Right, my lord. Let us see your guidelines. Your guidelines at page 7 categorically says general grounds for rejection. These are not exhaustive. We agree with that. Please come to the page numbers at the bottom, 7. General grounds for rejection are not exhaustive. We agree. If you say that, we agree with you. These are not all. There may be other grounds also. But C19 is the only skin disease area which has been highlighted here, which says chronic skin disease. And examples are given: vitiligo, this vitiligo or what, leprosy, eczema, chronic extensive fungal dermatitis. Now, this is entirely different from someone having a dhobizic sort of thing. This is basically a fungal infection which arises from, various reasons due to the monsoons also. It's very common in every person. There is no reflection of chronic disease, and it's the report on which you rely says it's non-communicable and is curable. So curable itself
my lord.
is
We did not-
contrary to.
My lord, please understand. We did not refer the petitioner to any.
You
third
might
opinion.
not have referred, but you rely on that and give this review committee report.
But I
The
may not
review co-
accept it. There is no rider on me
If
to
you
accept
did not
it.
accept, you would not have anything to say. You accepted that, and on the
No,
basis of that,
I just referred it, my lord.
you referred to that.
But
And
we never said that we are relying on it. That there was an opinion that with this diagnosis, that much. It neither shows that I'm relying it, neither shows that nor shows that I'm
you
not.
use that opinion to validate your own report. You see,
In fact, my
you
lord,
referred to that. Then there was no use of putting it in your report at all. Why should you refer to it?
in fact, they have simply copied, my lords. No tests were conducted by the review medical board.
Take your seat.
My lord, there are a set of examinations to be done in starts from page 34 onwards.
Yes.
Lots of got it.
Onwards, yes.
My lord, examination of the inconvenience.
36 onwards, probably. No.
34, my lord. In my this 34
Oh, these guidelines.
guideline.
Acha, acha.
I'm sorry, my lord.
No, it's fine.
Actually, my with the
No,
my-
absolutely.
with the
Because we are
congestion,
on-
my voice is lowered. 20 decibels.
Yes. 34?
My lord, Justice Bhattacharya got it. My lord, both of
Yes,
you
yes, both
lordships are
of
just
us.
Bhattacharya.
Yes. Double Y and single Y both have got it. Yes.
Examination of the inguinal
It's
region.
very
and
difficult to miss this page.
Lordship.
It's very difficult to miss this page for obvious reasons. So we are both on the same page, literally. Yes, Mr. Mujumdar.
My lord, skin diseases.
Right.
Like eczema, scabies, boils, fungal infection, etc. So it is not exhaustive here also. These diseases are common in the scrotal region and groin and may extend to the hips also and are to be disqualified if extensive. So my lord will find in this case it has extended to the hips and it is extensive and it is severe.
কিন্তু বলছে যেটা উনি বলছে স্কিন ডিজিজ এখানে কভার করছে এখানে বলছে যে আর ডিসপোলিফেটিক এক্সটেন্সিভ এখানে টনিক বললো না আর এখানে বলছে জেনারেল গ্রাউন্ড ফর রিজেকশন এটা এক্সস্টিভ না এগুলো বলে রিজেক্ট হবে কিন্তু শুধু এগুলো না
Now, your lordship takes page 120, severe infection on the perineum and buttock. So it has extended, which squarely matches with the condition that right.
This is page
120, my lord.
Oh, that one. Yes.
So this finding stands.
Now, Mr. Mujumdar, let us come back to this Supreme Court judgment, which
Lordship.
Mr. Rai has cited. There, the stress has been laid on remediable and not of permanent
My
character.
lord, that was pertaining to police, state police. My lord,
It's also a disciplined forces, supposed to be
but
disciplined.
there is a difference between that. They are disciplined force, well, with a big question mark.
Still now also.
They have to prove it. Only one
We'll
month.
record that.
Well,
We'll
only-
record as your submission.
My lord,
There's a question mark to the discipline of the police
my
force.
lord, union
And
always,
you are submitting it today.
union always questions the state. That's the federal.
That's a habit.
That is the federal structure.
So irrespective of the number of engines.
Whatever.
Irrespective of the number of engines.
Whatever. That sweetens our relationship.
Right.
Always continues. No, my lord, this Supreme Court judgment is always salutable, my lord. That is, we have to bow down to it. But it should apply to the fact situation of the case.
Hmm.
I did not tell you, lordship, about this factum of applying a judicial precedent. But I think that was judgment Supreme Court. It was, my lord, if I permit, it is found that the petitioner was suffering from medical problem known as DNS, a deviated nasal septum. My lord, I also suffer from that. So much so that your lordship can very well, sitting on the bench, find my nose is bent.
Thank God you are not appearing for any.
My lord, I am above that age. I would love to become a general of the army, but I am above that age.
You have a fascination for them, we know.
My lord?
You have a fascination for that. And you have made opportunities for us also on certain occasions to visit the.
Yes, my lord. Your lordship is very correct. I really love them. Their things.
No, that's fine. I mean, why not?
And my lord, I had an opportunity to very closely observe a tank in operation.
Tank in operation?
On a representation made by the petitioner was again medically examined by the medical board, which affirmed the findings and found him to be fit on account of aforesaid medical condition. The condition of the petitioner was challenging the action of the part of the petitioner under 32 the Constitution of India has been filed with following prayers. And that case, the Honorable Court finds, okay, there is a bent of the nose, allow him. And your lordship has in very many places repeated and agreed over that judgment should be read whole. Not so we don't find any similar semblance of the fact situation attending that case with this one.
Expensive. এটাকে রেড উইথ ওটা করো Yes, Mr.
My lord.
Yes, Mr. We want to.
My lord, kindly considers that there are species of medical ailments.
No, we cannot, you are right, we cannot enter into the expertise part. We cannot do that. We have to look at only your report and whether natural justice has been followed, he has been given. But although he says that the same day and all these things, but we have to see whether there is any arbitrariness, as you rightly pointed out, or any as such perversity in your report, especially. It has to be
or there was some animosity shown.
Animosity has not been established or period by him. We cannot go into that.
That is why, my lord, the honorable.
No, even if you do it mechanically without any animosity, Mr. Mujumdar, it may be. Because you cannot have any may not have. Why should you have any animosity against a particular candidate? That has not been pleaded even.
No, it has not been pleaded. I am not.
We do
No, my lord, I am not taking your lordship into that. But still, when the question came up, my lord, just for the information to the court, my lord, when a person is selected or he applies for to be appointed as a personnel of a armed force, the day one his selection starts, the state exchequer is being taxed.
Yes.
And before he enters the training stage, a substantial amount of the state exchequer is spent behind him. So, my lord, the mechanical part, it obviously appears, my lord, because there is a common connotation, Fauji Buddhi, but that does not apply. Now, my lord, kindly let us look at the impugned order. My learned friend has first to satisfy your lordship that this order is bad.
2 or 3 things we are pointing out to you, which may be considered to be bad in this order, so that you can argue. Otherwise, it's appellate court, intra-court appeal, you know the usual. Why judgments? We always say that. Very limited scope. Now, 2 or 3 things, please come to page 5. Court is right. The court says that the contention of the petitioner, page 5, the last few sentences. Lines. The contention of the petitioner that such condition is curable and non, even if accepted, cannot by itself render the decision of the medical board arbitrary, biased, or actuated by malafide. Malafide, no. Ruled out. Arbitrary. Biased or actuated by malafide, we are not satisfied, no pleading. Only arbitrariness. And standard of medical fitness for recruitment to the PAFs are necessarily stringent, having regard to the nature. Agree with this. Now, next, it is within the domain of the expert medical authorities to assess the overall fitness of a candidate, including the possibility of reoccurrence. There is no reflection whatsoever in any one of these reports.
No, my lord,
that there is a possibility
yes,
or chronic.
this was the honorable judge's reflection.
There,
because there are certain things that the petitioner wanted the court to read into the report.
Yes.
That was not apparent.
But reoccurrence is
It is not referred there, but it is the thought process of the judge, my lord. My lord, a person cannot be restrained while he is thinking.
No.
So the honorable judge said that even it might happen so, because the petitioner was asking his lordship to conjure a lot of things. Now, as your lordship rightly pointed out, arbitrariness, biasness are not apparent on the face of record. Now,
bias is not, we said bias and malafides are not.
Not on
arbitrariness, we have to consider.
My lord, now let us take bias and malafide.
Bias and malafide is not there.
Now, my lord, I try to impress upon your lordship, there was a malafide. It will be hypothetical thinking on my part, throwing on the court. So, to counter that, if your lordship has to write a judgment, your lordship has to counter it by hypothetical statements. That is why his lordship was, it is within the domain of expert medical authorities to assess the overall fitness of the candidate, including the process. Now, lordship does not say that in the report, the doctors has said reoccurrence. What he says is, it is within the domain of the medical expert to consider these aspects.
Mr. Mujumdar, we cannot enter into the medical expertise part. We are to look at your reports, right? And they have annexed a report, subsequent report, which shows it's curable. So 2 or 3 things against you, if at all. One is that remedial and curable, not of permanent character, appeals to us also, independently of the judgment also. Because on a particular day, I may have a hoarse throat. That does not mean that I'll continue to have it unless...
Like today I am having one.
Yes. And so therefore, Mr. Mujumdar, if there was any reflection of chronicity, it's chronic.
My lord, if I may.
Yes.
My lord was persuaded to hold this view when my lord was reading 19 in under page 7. So that was the general condition. Now, I take your lordships to the breakdown of the medical examination, which part has to be dealt in which manner. And there at page 34, we find that this line has been very specifically written.
But page 7 and 34 have to be read together. It's a part of the same...
General principle cannot come into the way of a specific examination.
Right. But
if the general, reading a heart condition, then the heart condition generally may say that with P74, it is okay. But while your lordship may find, while examining the heart, certain other parameters may be taken into consideration. Even if we read 17, 19 and 34 together, 34 will prevail because it specifically relates to a particular thing to be done in a particular way.
Very well, Mr. Mujumdar, we understand what you are saying. You want to add anything else? We'll reserve judgment on this. We are a bit in a dilemma to what to do. We'll reserve judgment on this because of the dilemma. Otherwise, you could have passed it in open court, but we'll just think about,
My lords,
we'll
if I
sit
may-
over it.
My lords, if I may place one more judgment, my lord, it's the same.
No, no
fact.
further. judgment.
My
In
lord,
reply,
this-
no further. judgment.
This is a very benefit of appearing before sensitive bench and also the bench.
No, we are being very candid, Mr. Moyuddin, because
No, my lord, I have been appealing.
your
before
arguments are very convincing.
No, my lord,
undoubtedly.
thing
We
is this,
can-
another thing that is paramount that also played in the mind of the learned single judge was this. My lord, this selection process, my lord, jokes apart, police force is a disciplined force, no doubt about that.
No, we
But
understand. we
my lord, the nature of duty cast on the police and the nature of
Definitely.
duty cast on the security forces,
Internal and country. We understand.
international. So, my lord, there the conditions are very stringent.
Very well. Let us come back to him, then, Mr. Rai. You want to add anything, Mr. Moyuddin? This is the basis of your.
The basis of the, my lord, I've showed only that how the breakdown is there.
Yes, we'll take note of page 34. Whatever we do, this first of all, that the subsequent one is independently obtained by him. Secondly, that the first one also, that was also, you say that it was not referred to, and it was just mentioned in the passing, cursorily in your report. But that might not have been the only basis of the report. There is no indication of that. And page 34 is obviously there. Yes, Mr. Wright, two things. One is this 34. Page 34, please come to that of the guidelines.
No, the other thing.
Page 34, yes, my lord.
34. Please come to this examination of this region. Now, number 3 says, look for skin diseases. Just see the examples: eczema, scabies, boils. Boils are temporary. And fungal infection, etc. Fungal infection is very generic, not chronic. These diseases are common in scrotal skin and groin and may extend to hips also, are to be disqualified if extensive. Extensive, it is stated. Severe, it is stated in the report. We are speaking against you because we are hearing. Severe is stated, extensive, the region has been mentioned there. So as per this examination, that was general, page 7. As Mr. Punjundar rightly pointed out, that is general. These can be conditions. If it's chronic, it's obviously ruled out. But those are not exhaustive. Here it's stated what is to be examined, and fungal infection rules you out if extensive. It was extensive, severe. So why should he not see this judgment of the Honorable Supreme Court in context? Septum deviation is your nose, the middle, the partition is deviation. There's a deviation, which may cause breathing problems. In high altitude areas, you may have difficulties for BSF. Yes, remediable permanent character was taken. But here we see the guidelines themselves. There, Supreme Court did not refer to any guidelines. It was a general observation. Here we have the guidelines. They adhered to these guidelines and disqualified it. One court, learned single judge, has expressed his views one way or the other. Just because another view is possible, should this appellate court substitute its own views for that? That's debarred. We cannot substitute our views, even if on the facts another view is possible, which is possible. But we cannot set aside the judgment unless it is wrong. So what do you say to that?
My lords, in any event, my lords, for rejection on for a skin lesion, for a skin infection, the reason to disqualify would be it would render him incapable of serving, of discharging his post, my lords.
Yes.
Yes. My lords,
So we cannot go into that. They have a guideline in place that has been adhered to, which says if there is fungal infection which is extensive, he will be examined and disqualified. Page 34 is very crucial to you. Otherwise, you had a very good case, but page 34 prevents us. So we'll see whether we can get over page 34. That is the only purpose we are keeping it.
But in the
reserved.
guidelines, my lords,
There is no other reason.
in that particular portion, the aspect of curability has not been stated.
That is the difficulty, Mr. Rai. See,
That
chronic
ought to be considered.
chronic rules out curability. If it says chronic, if it is only chronic, then if it's curable, it cannot be chronic. We understand that. Here, see where the examination part is there, it does not refer to that. If on the date of the examination he had a fungal inspection which is extensive, that itself is a disqualification as per this number 3, page 34. That is the difficulty. It's their guideline, they are bound by it, and they adhere to it. So if you make an exception for you, that will be contrary to the guidelines. And why should you do that? And particularly, there is no malafide established here or pleaded also. Let us see if you reading the two together, page 7 and 34, that is the only chance, but there's a slim chance you have.
If I may place one more judgment, my lords, just for my satisfaction, my lords.
Satisfy yourself.
The
Yes.
facts pertaining to this case, very similar, my lords.
You
the
know,
present
copy,
case.
usual rule applies. Delhi High Court Division Bench?
Yes, my lords.
Yes.
The senior cruris, my lords, it has been allowed, my lords.
We are seriously thinking whether we should take note of your argument regarding police force.
No,
The distinction. Yes, where? Which paragraph?
I know your lordship.
Which paragraph, Mr. Rai?
My lord, from page 7, it'd be relevant, my lords.
Ram.
But page 17 is the guideline. Please come to, para 17.
I mean, page 3, my lords, I'm sorry. Paragraph 7, I meant to say paragraph.
Paragraph 7.
Page 3, paragraph 7.
Same disease.
Yes. Same disease, my lords, subsequently it has been allowed.
No, but their guidelines might have been different. We don't know
Maybe,
that.
my lords, but
That may be because please come to para 17.
I have sufficiently established that I have been cured, my lords.
Para 7 you rely on. Please come to para 17 of this judgment.
Para 17.
We are reading it for you. While there can be no dispute on the proposition that the consistent view of the medical board and the review board is to be accorded due recognition and cannot be interfered with in a casual manner, especially keeping in view the fact that the courts are not medical experts. At the same time, where the medical board has not opined on the above vital aspect, candidate would require a further examination to opine on the same. Now, what is the vital aspect? Let us come back. See, a provision has been referred to here. Para 14 and 15. If you please come there, it says stipulation in Rule 24.2. We are reading it for you, no difficulty. You just hear us. Rule 24.2 says the medical examination shall be conducted in accordance with the instructions contained in appendix such and such. The medical officer shall test the eyesight, speech, hearing of the candidate, his freedom from physical defects, organic or contagious disease, his age, other defects, likely to render him unfit for police service. So this is the language. In the context of this, it is said, recorded by the court. So medical board should specifically look for the presence of inter alia organic or contagious disease likely to render him unfit for police service. There is no such provision here in their BSF's guideline. We'll further look into the guidelines also, but it's clear. The examination is what is the doctor to look at. That's very specified. So there's a line of distinction between these guidelines and BSF guidelines. We'd love to give a young man another chance, but provided it's provided for in the law, and our love cannot override that the proposition of law that a learned single judge has taken a view. If that's reasonable, not erroneous, then we cannot interfere, Mr. Lai. We have a slim chance, but still we are keeping our judgment reserves. We'll test our conscience and the law.
Yes,
Judicial conscience. Hearing is concluded, the matter is reserved for judgment. There's no scope of interim order here. There's no. We'll try to be as fast as possible.
My lord, only one thing. My lord, I'm here till tomorrow.
You are?
Here till tomorrow. Tomorrow evening, I have to go to and appear on 10th.
You will just take that. If you lose, then you take a decision that appeal has to be preferred. If you don't, then there is no question of your being present.
No, my lord, I really appreciate one thing. My two young friends, they have fought.
Yes, we have to protect them from you also.
My lord, ask them.
You cannot intimidate them.
Also. My lord, next day I will come with my hair dyed up black.
Then you have a better chance.
You look younger.
Much better chance. Much better chance. If you come in torn gown, hair dyed, even better chance if you change your gender also. But
that's quite.
Those are probably of a chronic nature.
Well, that's very costly, my lord.
Very costly. So let us make do with what you have. Yes. Yes, sir. Thank you.
Thank you.
Next. Acha, 24,
May I be
25
permitted to
is
appear
possible.
virtually?
Yes, yes, absolutely. 24.
Lordship,
You are for the
kindly-
appellant.
I'm for the appellant, my lord.
Mr. Shah, you are for the yes.
Yes, my lord. I'm for the appellants, my lord. My lord,
Yes.
kindly, there is a stay application which is yet to be filed. It will be filed today. Kindly, my lord, this will take up the matter on Wednesday. I'll make the service and come back.
Very well, very well. No difficult. Wednesday.
Grateful, my
Wednesday
lords.
দিয়ে দিও। Order record করছি।
Can it be Milord, Monday Milord? Otherwise, Milord, the state is the party Milord.
Huh?
State is the party Milord.
Wednesday?
There is option.
State is party, so what? You have to get yourself prepared in some matters. Wednesday is sufficient time.
Grateful, my lords.
48 hours. 48 hours is much. Yes, next, 25.
25, Lordship, I'm praying for 1 week's accommodation. I have
You
to
are for the
file-
appellant?
Yes, I'm for the appellant.
Yes, not this week.
Grateful.
Ever pass over matter.
Item number 6, pass over item.
My lord, I appear for the petitioner, my lord. This is an.
The other side is not, that's the difficulty.
My lord, other side have tendered all the written objection and everything, my lord.
No, but they,
But the erstwhile-
who is the other state?
Yes.
State, there is some difficulty. The state advocates actually met us in our chambers also, and they submitted in open court also. They request some more time.
The problem is, my lord, out of 10 years imprisonment here, the accused have suffered already 4 years. Justice Boshak was of the opinion that he should be granted bail as a suspended sentence.
What happened?
Now the
If you can hand
problem
over a
was the
copy.
hyper-technical issues of serving the petition, serving the victim.
Complaint. The victim.
Victim has been served. Everything has been done for last 2 circuits. It has.
No,
it has been
if you can
delayed
serve
for-
a copy to me today, day after tomorrow, we will have.
Fair enough. Fair enough.
I say that on behalf of this.
On the prayer of learned AAG, the matter is adjourned till June,
You hand over a copy.
Thursday.
আমি এখান থেকে দিয়ে দিচ্ছি।
Thursday. Day after tomorrow. June 10, 2026. It will be taken up on Wednesday, day after tomorrow.
এটা নিয়ে।
Day after tomorrow, both of you.
Very good.
Day after tomorrow, my lord.
I am obliged.
Thank you, Mr. Amish. Thank you for the fairness.
No.
Number 26.
Registration, move it.
It's a restoration matter, but Uday Babu will appear.
Who is
Uday Kumar Chakraborty,
So I can explain it in.
senior advocate, will appear
little bit
virtually.
Uday Kumar
Actually,
Chakraborty,
what
senior
happened
advocate, you don't know any such senior advocate.
I am led by Arun Kumar.
Your senior maybe, not a senior advocate. Uday Kumar Chakraborty.
I can explain, lords, because the weather here North Bengal is very pleasant. They filed this appeal. Now suddenly it was dark cloud and the Honorable Justice Basak was to appear. So therefore they didn't appear. Then Milords, they filed a restoration because the weather again became fine. The sun was there and pleasant and sunny. Then again Justice Basak was there. Again they didn't appear. Again dismissed. Thereafter Milords, they again filed a restoration.
Next. Justice Bosak is due to come when next?
Next circuit.
Next circuit.
So again the weather would not be fine.
We'll keep it in
So
the
they
next
want to do it in this circuit before my lordship. There is a limitation application, 115 days delay.
What is
That
the
I think
reason
my
for
lordship,
that? You come prepared in the matter. We'll take it up tomorrow.
tomorrow we will do it.
Tomorrow.
We are ready for the matter.
We are keeping it tomorrow. No, not today only. Just
My
not
lord.
today. Please come prepared. If he's not there, you have to move the matter.
Illegal
Second time you have
construction matter. I am obvious.
Thanks.
Item number 27.
Lordship, I am for the appellant.
Yes.
Lordship, I have filed a restoration application, Lordship. We have served copy upon the opposite parties, Lordship. There is a delay of 110 days, Lordship.
What is the reason given?
Lordship, the advocate on record, he is suffering fever during that time, Lordship, on the matter.
It's a composite application for condonation or different applications for condonation 1 and restoration 1.
Yes,
Separate application.
yes.
He was suffering on the date of dismissal for default also.
Yes, yes.
What happened in the interregnum?
Lordship, the informed the appellant, Lordship, as she was senior citizen, she was also suffering some old age ailment.
You are a habitual defaulter. This was a section 5 application in the first place of 1570 days. 1570 days limitation act application that was dismissed for default. Again, you are delayed. So you are a habitual defaulter. Why should you condone this delay?
Lordship, kindly condone, restored the application and hard on the merit, Lordship. Lordship, restored the application.
Although the respondents have previously been served, comma, none appears for the respondents at the time of call. Push up next para. It transpires from the averments made in the condonation application that the appellant could not file the restoration application in time due to a medical emergency. Push up next para. Upon hearing learned counsel for the petitioner, comma, we are convinced that sufficient grounds for the delay have been made out. Accordingly, can 4 of 2026 is allowed, thereby condoning the delay in preferring can 3 of 2026. Push up next para. We find from the averments made in can 3 of 2026 that on the day when the matter was dismissed for default, comma, the learned advocate for the appellants could not attend court due to illness. Push up next para. Since the said ground is sufficient for the purpose of restoration, comma, can 3 of 2026 is also allowed, comma, thereby condoning the recalling the order dated November 4, 2025 and restoring can 1 of 2025, comma, can 2 of 2025 as well as FAT 17 of 2025 to their original file and number. Push up next para. The appellant shall serve afresh copies of can 1 of 2025 and can 2 of 2025 on the respondents, indicating that the applications shall next be listed on June 17, 2026, when an affidavit of service to that effect shall be filed by the appellants. 17th June, immediately serve on that. 1 and 2, because which was served long back, so serve it.
Grateful.
Thank you.
Item number 28.
Not today.
Yeah, item 28, I'm praying for adjournment today.
Granted. Yes. Not today only, you have to come prepared tomorrow.
I am led by Mr. Bari in this matter.
Even if he's not there, you have to move it. Yes.
Item number 29.
Not today.
For the respondent.
মুখ দেখে বুঝতে পারছেন উনি করবেন না। Not today.
29, my lord. Sorry.
28 was made not today? No, 29.
29, my lord. 29. Union of
He Dipankar কোনটা ডাকলি?
Union to. No, no, sir, I mistaken. It's Union of India, my lord.
29 not today. Yes.
Item number 30.
There is a confusion now, Mr. Bhattacharya.
Yes, I'm sorry, my lord. Sorry to
No, there
my lord.
obvious
My lord,
confusion. Yes.
This matter may can you fix on Thursday, my lord?
Why Thursday? Come back tomorrow. You are for the respondent.
Yes, because they are not present.
That's why it should be taken up on Thursday.
No, no, my lord, with my.
Very well, Thursday. Thursday. It is Thursday. Thursday means 11th June.
No, 30.
No,
30. You're appearing?
Yes, madam. 30 I am appearing. That was for 29.
29.
That was for item number 29. 39.
29 gone. 30 call karo.
Item number 30.
Yes, move it.
Lordship, I'm for the respondent in this present application.
Right. Now,
Your Lordship, today's,
yes.
may I plead?
Yes, appellant, what is your can?
Can
Can is your can?
Respondent.
Can 3 is my application.
Good.
Your Lordship, actually, prior to this, by a white can 2, the matter was settled, and the terms of settlement was filed by through this can application 2.
Subsequently, the Honorable Court was pleased to dispose of the state appeal application in terms of the state terms of settlement, and a decree was directed to be drawn up on the basis of the state terms of settlement. Subsequently, what happened is that settlement did not materialize. Even on that day, and even now, I'm willing to pay the said amount. It is with regard to a specific performance of contract act.
Their
Specific
conduct was
performance
very
of
bad
contract.
since beginning.
We're taking a short break and coming back in 10 minutes. We'll continue with this matter.
Your Lordships, may.
Please. So you
as I
said the
was-
compromise was arrived at and it was recorded also.
It was recorded.
What is the nature of the suit from which this appeal arose?
The suit for specific performance of contract.
Plaintiff, they are the plaintiff.
They are the.
I'm the defendant. They are the
I'm
plaintiff.
the plaintiff. And subsequently, there was an injunction order, and hence this appeal was filed by the.
So you had to pay and they had to execute a deed.
My and if your lordship goes sees that I have paid about my demand draft of 50 lakhs is
No, let us see these terms of settlement first.
terms of settlement is
That
two
can
application
two,
page,
can two. Actually, let's come to can two.
They have annexed in the.
Page 13.
They've annexed in
Schedule.
can three.
Annexed in can 3.
Which page?
Page 13 of can 3 application.
Page 13.
13. Page 13.
Right.
The schedule.
Yes.
Now the terms of settlement was
So you complied with the entire thing? No.
my that is the issue. Your Honor.
My lord, give me a short brief of all that matter. Agreement was executed on a.
No, they are the petitioner. Let them move first.
I'm not going on the merits. Your Honor. I'm just concerned with
What
this
have you
matter.
not done as per this?
As per
Nothing.
this, I was bound to pay. The amount is lying with me. On that day, it was lying with me. I've requested them to submit their documents for the registration of process to generate a query. I have issued checks, demand drafts in their name, but they did not respond to my calls. I have annexed my WhatsApp messages as well, where I have requested them to please hand me their documents, hand me their bank details so that I can pay the amount. A term of a period of 20 working days was agreed upon, where the seed payment was to be given and the land was to be registered in my favor. Now, within the span of that 20 working days, I've contacted them several times. I've requested them for their documents to generate the query, to proceed with the registration process, payment. I've annexed all my
This is regarding the remaining amount of 68 lakh.
68 lakhs.
Roman 5, Roman 4. Para.
50 lakhs is
Within
pending.
20 working days.
Within
So
20.
within 20 working days, you are saying that you send them messages, give your bank details?
Numerous calls. I personally, me being a counsel, I personally visited the residence of the petitioner, but I was denied even entering their house. That was the condition. I was turned out from their door.
Where have you stated that? Let us see your paragraph. Oh, what's para 7, 6
WhatsApp
and 7.
6 and 7. I have annexed the WhatsApp messages as well. As the petitioner is a very old person, he did not have a WhatsApp. I've WhatsApped to his counsel, learned counsel.
P4 is that page?
P4 is
WhatsApp messages?
WhatsApp messages is in page 23, 22 and 23 on two separate dates, on 13th of July, on 16th of July.
Yes, what do you say to this? You cannot frustrate the terms of settlement.
They
No,
have
my
not
lord.
even,
I did
they
not
didn't have the
frustrate.
courtesy to even
My lord,
reply to my
my lord,
messages.
kindly,
Let us hear
kindly
him,
bear
yes.
bear
Yes,
with me for a
yes,
moment.
yes.
The terms of settlement was that they have already paid 50 lakhs draft to the honorable court and it is lying with the honorable court. And the 68 lakhs they will pay me within 20 working days. They did not make the payment. They are now taking a plea that I did not provide them the document. Earlier transactions were taken
Not
place.
document, bank account.
Bank account. The earlier transactions were taking place. The amount they initially they paid me 43 lakhs. I have refunded that amount because they could not perform their part of obligation within the estimated period of time. I refunded that amount to them. The bank account detail was always available with them. The amount of 50 lakhs draft that is lying with the honorable court, I did not receive because those draft was prepared by a third party in my name, not by the plaintiff. Because I do not want to enter into any third party transaction for selling my land. Because I have agreement with
You
them.
could have just replied to this WhatsApp that already it's available with you.
I was not the conducting lawyer at that
No,
time.
not you, your client.
They
can't
they
frustrate
did
the
not
order.
WhatsApp to the client directly. To
But it
the
was
earlier
counsel.
counsel.
It was
Counsel.
the counsel of the trial
Because
court.
the dependent is
So
a
give the account number, they'll
No,
that was
no,
that was only the issue.
not on the issue is not on that, my lord. Their conduct.
What conduct? Terms of settlement
Terms of
entered into
settlement
by
is
both
there.
of you.
Terms of settlement is there.
What is your conduct also?
My
You could
lord,
have
kindly, my
given
lord,
the-
my lord, kindly. My conduct, I will come to.
And in your application, you asked for a recall of that order.
Recall of that order.
If you ask, you have not sought for implementation, you ask for a recall means that order goes.
That's the reason why 20 working days has already been over, and by that order,
You want a recall of that order, so therefore there is no settlement then.
they have. I have tried numerous times, even today.
So now what is your prayer? You have asked for a
They-
recall of
I've
that order.
I've
Let the
desperately
recall be
prayed for
allowed.
recalling of the order. Your
So
Honor.
recall means you want to
Let it be restored. Let it be decided
hard
on
out on
merits.
merit.
Let it be decided on merits.
Both of you agree, then we'll do that. So whatever money has been transacted between you, what happens to
I
that?
have paid
Only,
25
only,
lakhs.
only they have sent me, they are saying in one hand that they do not have the bank account detail. They send me 25 lakhs, that too
So
after.
at present, what amount is with you? Their amount? 25, what is
No,
the amount?
32 lakhs only.
You agree that? Agree to that?
7 lakhs was paid at S1.
Earlier,
Total 32 lakh.
25 lakhs.
So now 32 lakh has been paid by you, that's lying with them. Whatever may be the fate of the appeal, that will be subject to that.
And 50, your lordship, maybe please, 50 lakhs is submitted.
That is third party draft.
50 lakh is already lying with the court. That was
Lying with the
directly to
honorable
be paid to them. That has not been paid to you.
No, not paid to me.
The demand draft is lying before the
Lying with them.
That means the money
That
is
has
with them.
expired
That
by
means
now.
money is
That
with
is
them.
expired. That's true.
That has expired.
That
That
has
has
expired. That was within the span of 20 working days. It would
Yeah,
have
both of
been
you
credited.
agreed to the same thing we were passing.
Lordship, in the meantime, as the matter was
The
not
paper
heard,
book was, paper books were prepared in the appeal.
paper books have not been prepared.
So directly prepare the paper books and the usual things.
My lord, I don't think paper book would be required because they are also relying on the same set of documents.
No, evidence will be required. Evidence and all.
No,
No, it
This
is,
is
I have challenged the injunction order only.
Injunction.
Oh,
Injunction
injunction.
order, my lord.
Still prepared in front of paper books. No difficulty on that.
My lord, the suit.
All the annexes are there in the injunction
Yes, my
application.
lord, yes, all the.
Then, your lordship, may I be given the liberty to reply to that application, appeal application? Can 1 and the main memorandum of appeal.
What was Can 1 and Can 2?
Can one is the stay the application for
So you will
stay.
file an application rebuttal to that. Can 1.
Can 1,
Stay.
along with, they have served me the copy of memorandum of appeal as well.
Memorandum, there is no scope of
There
any
is no,
opposition.
Then I'll reply to Can 1. Your lordship.
Very good. Appeal was formally admitted.
Yes, madam. And a FMA number has been provided.
No, sometimes nowadays FMA number is given, but since court has decided it, so
Yeah,
it
it
deemed
Your
admissible.
lordship, even today I'm willing to
No,
comply with that.
Today's willingness is.
No, you cannot blow hot and cold in the same
No,
way.
no,
no,
Either
no,
you
I'm
agree to
saying
comply.
They are
with
always doing that. They are always doing that since beginning. The
Because
first,
I'm willing.
first
That's
check
the-
they have provided me
that's
was
the-
dishonored by the
the
dis-
background
dishonored
of
by their
the
bank.
background of the case is peculiar. Bishop, the appeal arises out of an order passed under Order 39 Rules 1 and 2 of the Code of Civil Procedure in connection with a suit for specific performance filed by the appellant. Next para. By an order dated June 19, 2025, a coordinate bench of this court had recorded that the appeal stood disposed of in terms of the terms of settlement entered into between the parties, as reflected in the schedule to Can 2 of 2025, and a decree be passed in terms thereof in the suit itself. Next para. However, the respondent stroke petitioner in the present application bearing Can 3 of 2025 submits that despite several communications via WhatsApp by the learned advocate for the respondent stroke petitioner to his counterpart appearing originally on behalf of the appellant, seeking particulars and details of the bank account of the appellant in order to transfer the money required to be paid by the respondent to the appellant, there was no respondent on the part of the no response on the part of the appellant, which led to the inability of the present petitioner to comply with the to adhere to the 20 working day period for making the balance payment in terms of the settlement. Next para. As such, the respondent stroke petitioner seeks a recall of the order recording compromise, as allegedly, due to the non-responsiveness of the appellant, the said agreement could not reach fruition. Because of next para, learned counsel appearing for the appellant stroke opposite party rebuts the contentions of the respondent stroke petitioner and submits that since there were previous transactions between the parties and the bank account particulars of the appellant were well known to the respondent all along, comma, the flimsy excuse of non-furnishing bank account particulars was merely used as a pretext by the respondent not to comply with the terms of settlement. For sub next para, it is further pointed out by learned counsel for the appellant, comma, that the respondent's advocate wrote to the erstwhile learned advocate appearing for the appellant without directly communicating with the appellant. Full stop, next para, thus, comma, it cannot be said that the conduct of the respondent stroke petitioner is bona fide. Full stop, next para, be that as it may, comma, upon hearing learned counsel of the parties, for the parties, comma, we find that the parties are now ad idem to the appeal being heard on merits upon recall of the order recording the terms of settlement, comma, since the settlement has not reached fruitful culmination. Push up, next para, we hereby record that it is also admitted by both sides that at present, comma, our total amount of rupees 32 lakh, 32 lakh paid at different times by the respondent to the appellant, comma, is lying with the appellant. Push up, moreover, comma, an amount of rupees, what is deposited in the court?
50 lakhs.
50. An amount of rupees 50 lakh in total remains deposited with the court by way of demand drafts furnished by the respondent at different points of time. For sub next para, in view of the above development, comma, we deem it fit to recall the order recording compromise and direct the appeal to be heard on merits. Full stop. Needless to say, comma, the amounts indicated above shall be subject to the outcome, final outcome of the appeal. Full stop. Next para. Accordingly, can 3 of 2025 is allowed, comma, thereby recalling the order dated June 19, 2025 and restoring the appeal and appeal bearing FMET 7 of 2025 as well as can 1 of 2025 and can 1 of 2025 for hearing. Full stop. Next para, on the prayer of the respondent, comma, the respondent is directed to file affidavit in reply to the can 1 of 2025 within a fortnight.
My lord, if the matter may be expedited because the matter is pending since long and there
You already have a copy since long.
Within 2 weeks.
Within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. In view of the limited nature of the appeal, comma, the appeal shall be heard on the papers annexed to the memorandum of appeal as well as can 1 of 2025 by dispensing with the requirement of preparing paper books as well as calling for the records. Full stop. In view of the appearance of both parties, comma, the appeal be treated to be ready as regards service and otherwise ready for hearing. Full stop. Next para. The appeal be listed along with the application under the heading application in the before the appropriate bench of the next circuit. Full stop. It is made clear that the appeal shall be taken up for hearing along with the application on the returnable date.
Lordship, quick interjection. Your Lordship. The trial court case before the learned trial court was also directed to be decreed.
Decreed?
And disposed of. And if the state...
We are recalling that order. We have recalled that order. The trial court has not decreed because you have not paid the money.
Yes.
Grateful.
Thank Give your appearance, sir. Next.
Item number 31.
এই তুমি কর এটা যেটা রিজার্ভ করেছি ওটা সাইডে পড়েছিল আমারই ভুল ওটার মধ্যে আমার কপিটা দিয়ে দিই আইটেম কত নট টুডে দেখে যাও কেউ নেই বোধহয় সেম not today
Milord, service is not complete, Milord. It has been posted. If Milord matter can be fixed on Thursday, by that time it will be solved.
তাহলে থার্সডে করে দাও not today না কর থার্সডে 11 থার্সডে হ্যাঁ
33 lordship appear for the petitioner lordship. This is a restoration application
Yes.
lordship.
I
My
appear
lord.
for the state of West Bengal.
yes
My lord, the main answering respondent is Kuchbihar Jilla Regulatory.
you have served on all party all
Lord-
respondents
From this.
Lordship, earlier also I have served lordship.
you have served
Lordship, earlier also I have served. Perhaps lordship, my lord.
earlier occasion you have served আচ্ছা।
One only.
Lordship, all the respondents I have served lordship.
Hello, 2 and 3, I am not very sure whether I'll be representing. I'll just take instruction. With regard to 4, 5, 6, 7, my lord, what I have been informed is that they have a separate panel of lawyers.
no we don't have an affidavit of service on record Mr. Vedul. No affidavit of service is there on record
Lordship, my
there has to be an
learned
affidavit of
lordship,
service
lordship, kindly lordship, make it lordship, not today lordship.
Very well. Come back tomorrow. Ask your
Lordship.
learned junior to present the affidavit.
Lordship,
Sir, we'll take up
Lordship.
tomorrow. So,
Lordship,
God said we'll take it up tomorrow.
Lordship,
On the prayer of the appellant, let the matter stand adjourned for the day. Give your names.
Yes.
Thank you. Only for the respondents whom you are sure you are appearing for today.
One.
Yes. Petitioner হয়ে Mr. যে appear করছেন তার নাম।
Number 34.
My lord, I am for the petitioner, my lord, applicant. This is a restoration
Yes.
application, my lord. This is the first time, my lord. I could not video, my
Acha,
lord.
acha.
Some problem, technical problems there, my lord.
Right.
This is the matter, my lord.
Huh.
Matrimonial suit, my lord, regarding, my lord, section 13(1)(1)(a) in the Marriage Act, my lord. So, my lord.
This is
a
this registration is within time, Mr. Jacob. Registration
Yes,
is
yes, my
filed
lord.
within time.
Yes, my lord, within time, my lord.
Order 30 under the rule 4 এর principle apply থেকে ছিল না allow করে দিচ্ছি what is the reason absence reason for absence
Yes, my lord. That is para 2, my lord.
what that is technical defect very well.
Yes.
This the present application is for restoration of an order dated April 21 2026 whereby the appeal was dismissed for default push of next para since none appeared for either of the parties on the said date comma applying the principle of order 9 rule 4 of the order 9 rule 4 comma read with section 107 of the code of civil procedure comma we take up the application for hearing ex parte push of next para as per the averments made in the application comma due to technical issues in accessing the virtual hearing link comma the appellant could not be represented on the date of dismissal full stop being satisfied that sufficient reason for the absence of the appellant on the said date having been made out comma can 3 of 2026 is allowed thereby recalling the order dated April 21 2026 and restoring FAT 8 of 2026 to its original file and number. Mr. Chakraborty, the applications are still pending. Can 1 and 2?
Yes, my lord. This is section 5 also there, my lord, 95 days delay, my lord. So, my lord, you have to kindly
So
give
that-
direction to
All
Sar,
right,
my
very
lord,
well.
to the other side.
Very well.
As far as this.
The appellant
section
shall
5
serve. The appellant shall serve copies of Can 1 of 2026 and Can
and 2 also.
2 of 2026 on the respondent indicating that the applications shall next be listed before the appropriate bench of the next circuit when an affidavit of service to that effect shall be filed by the appellant. Thank you.
Deeply ordered.
Thank you. Yes.
Number 35.
কি হচ্ছে কি প্রবলেম হচ্ছে কোনো
Restoration.
কল্যাণ চক্রবর্তী appellant.
Milord, I am for the appellants, Milord.
Yes.
Milord, this is an application for restoration, Milord, of the mandamus appeal.
Within time.
Within time, Milord.
At least give a copy. What is the reason?
Milord, my learned advocate on record, Milord, was busy in another court, Milord, she could not
Not
appear.
good ground.
She could not appear, my lord. Another court, my lord, as in the High Court only, my lord, while the matter was called, she could not appear, my lord. It was
What provision of law? Is that a good ground? Mr. Mujindu, have you couched it in a different language?
Yes, my lord.
No, affidavit does not disclose which court, which agenda.
Yes, you're right, actually. Okay. Mr. There is no ground at all. Use a supplementary affidavit. This will create a bad precedent. Use a one-page supplementary, give a copy to us. You are making it your prayer.
Yes.
On the prayer of learned counsel for the appellant stroke petitioner, leave is granted to the appellant to file a supplementary affidavit with an advance copy to the learned advocate for the respondent. Push up. When should you keep it? Tell us.
Day after tomorrow.
So soon?
Well, by tomorrow we'll do it.
Well, let the matter be listed under the same heading on June 10, 2026.
I'm great.
Number 36. Not 36.
Not today.
Not 36.
You're appearing?
Yes, for the appellant, my only humble prayer, can this matter be listed on Thursday, subject to lawsuit's convenience, so that I can come
Thursday, very
physically and
good. Thursday. Thursday, could you order a good on Thursday?
Much appreciated.
Thank you. Yes.
37.
My lords, item number
37,
37.
I'm
I
for the
appeal
respondent number
appellant.
1.
You will move the matter? Very good. Very good. You are for the respondent?
Respondent number 1, my lord.
One.
Answering respondent.
Oh, actually, you appeared on that.
I was also defended in the.
So you are supporting him? Then dismiss.
Perhaps, my lord.
We will take it up after lunch because he is appearing. Yes, what is the matter?
My lords, the plaintiff, that is the respondent number 1, had filed a suit for recovery of possession, cancellation of deed, my lords. My lords, along with the
Cancellation of?
my deeds and
What was the deed?
my lord, deed of conveyance executed by the person who had sold the land to him had also sold the land to me, my lords.
Your purchase were prior?
No, my lords, my purchase is after the plaintiff, my lords.
Achha.
It was a power of attorney. The power of attorney holder sold to him as well as to me, my lords.
All right. Same power of attorney holder.
Same power of attorney. My lords, now what happened? They, along with this suit, they filed an application under Order 39, Rule 1 and 2. On the first date, my lords, an ad interim injunction was allowed.
Sorry, you are Mr. What is your name?
Nigam Mittal, my lords.
Mr. Mittal, what was their ground for cancellation?
My lords.
Their ground. Just tell us.
Must kindly allows me.
Mr. Ghosh, you can take all of you can take your seats. We will just come back to you.
My lords, their plaint begins from page number 36 of the
We won't read the plaint. You tell us. What is the basic ground? I mean, main, most important ground.
My lords, their ground for cancellation is
Yes.
on two limbs, my lords. My lords,
Yes.
first, they stated that while the deeds were executed, they were not aware of the execution of the such deeds in the year 2010, my lords. My lords, during the period of COVID, when my clients apparently went into the suit land, encroached upon the suit land and started illegally occupied his suit land, and when he made enquiry from his erstwhile owners, they informed him that some deeds are in my favor. Now, my lords, their claim is that the person who has executed the power of attorney has sold more than what he was eligible to sell from that power of attorney. And, my lords, they are claiming that in the year 2010, when my deeds were executed, that power of attorney was cancelled. Now, exact dates are not mentioned when the power of, whether it was before the deeds were executed or whether it was.
They had purchased the same property previously.
My lords, part of the property.
So they say what has been sold to you is in excess of what remained.
Yes, my lords. Yes,
Very well. So then what happened?
My lords, my case here is that the trial court on 3 parameters while judging the.
What has been done by the trial court? Injunction refused. Granted.
No, injunction granted in their favor.
Ad interim injunction.
No, my
Injunction
lords,
application is
contested. Injunction has been granted only to the effect that I shall not create any third party right interest.
So what is the wrong in that? The sub judice before the
Yes,
court.
my lords. I humbly bow down, my lords. My lords, but my only point of contention is that when the ad interim injunction was allowed, my documents were not on board, my lords. My lords, when I contested the Order 39 Wall 2 application, there is sufficient documents on record from my end which proves that they failed to establish a prima facie case. My lords, why? Because not one document from the plaintiff's end which showed that at any relevant point of time, either before the purchase or after the purchase, they actually obtained possession of the property. The entire factum of the case has been made out only to file the present suit. The fact remains that at no relevant point of time.
Suppose, Mr. Mittal, they did not take possession. Let us suppose the worst against them. Even then, their suit is broader, wider. They are also challenging the deed. I mean, they're asking for a cancellation of your deed.
Yes, my lord.
So on that ground itself, injunction should have been granted in aid of that. Even if recovery of possession, they may not have a good case.
My lords, if I may submit on that point. My lords, my case against that also is that they have specifically mentioned in the plaint, my lords, as per the Limitation Act, there is 3 years limitation for them to have the deeds cancelled, my lords. My lords, the suit is filed in the year 2023. My case is even if I take the best case scenario that in 2010, they were not aware of the fact that the deed has been executed in my favor. 2018, they were aware of the fact that the deed has been executed.
How do you say that?
My lords, there was a suit filed in which they were also a defendant with me. And the suit says that I am possessing a property which is beside the suit land, my lords.
Third party filed a suit. Third party filed a suit against both of you.
Yes, my lords.
They contested that.
They contested that. They were appearing in the suit, my lords. That suit was subsequently dismissed. There were 2 suits, my lords. One, their erstwhile owners had filed in the year 2018. Another suit which a third party had filed against both of us. And in their erstwhile owners in the year 2018 had filed a suit again for recovery of possession, my lords. That was also subsequently dismissed for default and had a specific prayer for recovery of possession, my lords. My lords, my submission on that parameter only on facts, my lords. I'm not that they had all the knowledge. This is just a clever drafting to just initiate this suit, my lord. My lord, they were hopelessly time barred before appearing before the learned.
Let's see how the trial court dealt with that.
My lord.
Come to the impugned order, please.
My lords, the impugned order is at page 101, starts from 101, my lord.
17th July order?
My lord, it's kind.
Yes.
My lord, it starts at 103, my lord.
We are following the memorandum, so you can refer to the internal pages of the order. You can follow from wherever you have your notings.
Yes, my lord.
Refer to the internal pages of the order.
My lord. My lord, impugned order, internal page number 4, my lord.
Right. Decision with reason.
Yes. My lord, the learned trial court has mentioned the points of determination, my lord.
Yes, let us see that. You can place in your own way.
Yes, my lords. My lords, then internal page number 5, my lords.
No, let us start from 4.
My lord.
Because he has discussed also after
My lord.
considering.
Yes. All the above points are considered together for determination for sake of brevity and convenience. After considering the facts of the instant case and taking the title in respect of the property, which is the subject matter of the instant suit, as well as taking the title of the defendants, which the defendants have alleged that they had rightfully purchased and have been enjoying and possessing since the year 1984, my lords. However, the fact is subject to evidence which cannot be considered at this stage while the court is adjudicating an injunction application. That apart, the instant suit is filed by the plaintiff with a prayer for declaration of his title, recovery of possession in respect of the suit property, which as per the allegation of the plaintiff, the defendants had forcefully encroached and illegally made construction thereupon. This fact is also subject to evidence which involves serious issues in those facts cannot be decided conclusively at this stage. Besides, from rival contention, it seems that both parties are in respective possession of the scheduled suit property. In view of the instant case and upon perusal of the case record, it appears that by order number 2, dated 24th of July 2023, this court was pleased to allow the injunction application of the plaintiff of the suit. Be that as it may, if the said order of the court is not allowed to continue, that may cause injustice to the plaintiff, since the subject matter of the suit involves many questions in regard to the title of both parties. Moreover, the assertion that made by the plaintiff and denied by the defendants in the written objection are subject to evidence, and without considering the evidence, it shall not be proper to reach any conclusion at the prima facie stage. At the cost of repetition and upon it perusal of the application of the plaintiff, it prima facie appears
Mr. Mittal, this paragraph which you are reading, there the next sentence says that you have not denied the title of the plaintiff. Is that correct?
Yes, my lords, but my specific submission is that, my lords, that in my plaint, I have specifically denied the title, my lords.
In your plaint
Yes,
means
my lord,
written statement.
in my written statement. my
What was
lord.
that paragraph of your written statement from your annexures? Or your written objection will be fine. I mean,
Yes,
you
ma'am.
can,
Yes, ma'am.
because this is at the injunction stage.
Yes, ma'am.
Your objection to the injunction. Where does your objection start? Which
My
page?
lord, my
Page
85.
85.
85.
yes, my lord.
Thank you. Thank you.
My lord, if your my lords permit me, can I come back with the instruction? My lord,
You cannot hit at the root of their title because that affects your title also.
yes, my lord. My lord, actually,
Do you understand what we are saying?
yes, my lord.
Because the source of title is the same.
Yes, my lord.
At best, your case is that they did not have title regarding a portion because that portion was extra above whatever your vendor had.
My lord,
These are arguable questions, Mr. Mittal. Why should you interfere at this stage in appeal? Let the suit proceed. You prove your case on evidence. You have argued very well before us, but that has to be done at the trial stage.
my lord, I'm repeating myself, my lord.
No,
but-
please do. Yes.
My lord, but my only contention remained that I had enough documents, whereas the plaintiffs, they failed.
Here, limitation is a mixed question. Your thrust was on limitation. Previous suit, previous litigation, limitation.
Yes, my lord.
That's obviously the thrust. But here it's a mixed question, where several things have to be, those documents have to be seen, those previous plaints have to be seen, their appearance, the proof of their appearance in those suits, or service of summons on them. Otherwise, they would not have knowledge of those suits, although filed against them. So these are to be proved. These are arguable cases. We'll record your submission that primarily you are on limitation, as well as you dispute the fact that yes.
My lords, my lords, for my satisfaction, if I may just point out one more document. My lords, I have annexed a copy of the site plan.
Your satisfaction or his satisfaction?
No, my lords, for my satisfaction.
Yes.
My
Which
lords,
page? Which page?
My lords, it's at page number 279, my lords. So of Can 1, my lords.
This folded thing?
Yes, my lords. My lords, I will not trouble my lords. My lords, this is an plan that was approved by the Siliguri Jalpaiguri Development Authority, my lords.
This is a matter of trial. Absolutely. The more you go into this, it's a matter of trial.
My lords, bow down, my lords.
The present challenge has been preferred. We are dismissing under order for rule. But Mr. Mittal, we appreciate your arguments. Mean it, not that just. The present challenge has been preferred against the dismissal, against an order whereby the injunction application filed by the plaintiff stroke respondents in a suit primarily for cancellation of a deed of title executed in favor of the
There are deeds.
Deeds of title executed in favor of the appellant were challenged and recovery of possession sought by the plaintiff stroke respondents. For the next para, learned counsel for the appellant assails the impugned order on several grounds, including that the learned trial judge did not advert to specifically the documents produced before the learned trial judge at the stage of final hearing of the injunction application by the defendant stroke appellant. First, it is submitted that from such documents as well as the averments made in the written objection to the injunction application, filed by the appellant, it would be evident that the plaintiff stroke respondents had prior knowledge of several other suits and consequentially, the deeds in question, hence rendering the suit barred by limitation, rendering the present suit barred by limitation. Push up next para, even otherwise, learned counsel seeks to rely on certain documents placed before the learned trial judge. Push up next para, however, on a perusal of the impugned order, we find that the learned trial judge adverted to the respective cases, respective arguments of the parties, although in a nutshell at the injunction stage, temporary injunction stage, and came to the conclusion that a detailed trial on evidence would be necessary to conclusively adjudicate the disputes between the parties. We also find from the materials sought to be relied on by the appellant that evidence on trial would be necessary to convince the court in favor of either party. Next para, as such, since a triable arguable issue has been made out, we do not find any illegality per se in the impugned order. Next para, however, we make it abundantly clear that the findings rendered in the impugned order would be tentative for the purpose of the temporary injunction application only and shall not have any binding effect at any further stage of the suit, including the final hearing of the same. So next para, with the above observation, we find no merits in the, we do not find any necessity to interfere. Hence, FMAT 3 of 2026 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Can 1 is a consequential step. Can 1 of 2026 is also consequentially disposed of, no arrest to cause certain
Just one indulgence. Although there was no direction, my lord, I've prepared an affidavit in opposition.
No, we have not admitted the appeal. If you take that on record, then you're gone. Yes, thank you.
Item number 38.
Not today.
Lordship, item number 38, I am appearing on behalf of the respondent.
Respondent won't do, not today.
Lordship, kindly keep it day after.
Why? Come back tomorrow.
Item number 39.
Lord, in item number 39, item number
Yes,
39, I am for the,
Yes.
this is my appeal.
Yes.
My lord,
Appearing for the first time.
no, this has appeared several times, my lord. Lordship kindly comes to last order of lordships of the,
Opposition.
yes, if I may place the order.
Opposition is no longer the opposition. Therefore, opposition will take some time, Mr. Mukherjee.
No, my lord, kindly seize the
State
order.
authorities are involved. So therefore, opposition will require time.
No, my
We'll
lord,
extend the time.
I am not on that. I am not on that. My lord, kindly seize
That is the last order.
Yes, that is the
Yes.
last order. Kindly seize reads the first part of the order. What
Yes.
happened? My appeal was dismissed. I filed a restoration application along with delay condonation application.
Yes.
Lordships, that was can 2 and can 3. Lordship kindly says the can 2 is allowed. My appeal is restored. Therefore, in my humble submission, that there cannot be any direction for any opposition for my condonation delay application. It was our inability to explain to the
honorable bench. And it is our mistake, my lord.
Distribution allow করে দিতে হবে conversation official scope কোথায়?
And can one, in which the opposition has been directed, already stands disposed of.
Mr.
I'll-
Kaji, apparently there was an inadvertence on the part of the court in the sense that probably the impression was that the restoration was of the condonation application. It appears from this order that the impression of the court was that there was the section 5 in filing the appeal was dismissed for default, and for that it was restoration. Therefore, court
Well,
restored the application.
That's why I made
But,
my first submission. It was an inability to explain. At the end of the day, it is our inability. And
No, but
my lord,
probably-
now
yes.
can one, if the direction is in respect of can one is also disposed of already. I'll say little background. I'll take 30 seconds. This is an
Can one is
appeal
disposed of?
Yes.
Oh, acha, yes.
This appeal arises out of an judgment and order of the LA judge Darjeeling. My client had filed the appeal initially at principal bench at Calcutta. They
Right.
filed can one before lordships, praying that the matter be taken up at principal bench. Lordships
That was
did
can
not-
one.
That was can one. Lordships did not allow and directed us to come back to the circuit. The can 2 and can 3 are the restoration application and condonation of delay application.
No. No, Mr. Mukherjee, you have been directed to, they have been directed to file opposition to can 1, which is
Yes.
apparently not the condonation of delay application.
No, therefore, my humble prayer, my lord, kindly regularizes this and allows the appeal to be heard. Let the lower court records be called for. Allow me to prepare the paper books and
But you have to hear the other side, Mr. Mukherjee. You have to give an opportunity of hearing. Give a notice, come back day after tomorrow. Whoever is appearing for the state, the current GP,
We shall-
GP has been appointed.
Yes.
Who is the GP?
I understand.
Mr.
I
Kulajit
understand that.
Mr.
Good friends of
Kulajit,
Mr. Dhar.
catch hold of him. He's gossiping with Ms. Acharya. Catch hold of him. Give him a copy.
I understand they are
Yes,
all
Mr.
good
GP,
friends of
please
Mr.
take it.
Dhar.
No.
No, Mr. Dhar, the relationship is culinary.
Yes. Lordship remembers.
No. Who will forget?
First,
You are the AGP or the GP now? A. Achha. None appears for the state at the time of call. First up, we request learned AGP who is present in court to accept service of a copy of the application and to represent the state on the returnable date. When should you keep it?
My lord, Thursday, if it is convenient, your lordship.
The matter shall next be listed under the same heading on June 11, 2026. We are just explaining to you in a nutshell. Here there was a can 2, which is an application for restoration. Can 3, condonation of that. Court observes can 2 is allowed, restoration granted.
The other one.
Then directs affidavit to be filed, affidavit in opposition to can 1 of 2025, which is taken to be a condonation of delay application. Can 1 was separate for that to be heard by the principal bench. So can 1 is in any event redundant, that was refused, directed the circuit bench to hear it. And if can 2 is allowed, 3 is automatically allowed. Apparently there was a misapprehension. So Mr. Mukherjee says that let this be regularized, and so let us come back on the 11th. Good. Thank you.
I'm obliged, my lord. I'm obliged.
Thank you, sir. Thank
Grateful,
you.
my lord.
Number 14.
Yes, 40. Yes. Why that expression? You're asking for time. Why that expression? Ask.
Well,
Yes.
the can 1 is the application for condonation of delay.
You have to
There's a
serve the
delay of 23 days, my lord. I have served, my lord. The affidavit of service is here. My lord, there is no state lordship. It's a partition suit.
Yes, we
My
were,
lord,
we were
we
watching
are-
for that one.
the
They have
applicant-
received, they have received.
My lord, the one of the defendant, my lord, I found that door is locked. But he is not, he is defendant, my lord. He's in my side. I am also the
Plaintiff
defendant.
has received.
Plaintiff received.
What is the delay?
My lord, delay is of 23 days, excluding the statutory period.
The reason for that?
Reason lordship, if your lordship kindly see the decree, my lord, the final decree has been drawn up and there was a direction to pay the necessary stamp duty for, my lord, engrossment of the duty.
Yes.
The plaintiff did not do so. My lord, even till date, my lord, they did not, my lord, deposit the stamp duty. The defendant, my lord, he waited for the certified copy of the, my lord,
Will allow me.
Yes.
The affidavit of service filed to be kept on record. Push-up. It transpires that despite service having been effected, the respondents remain unrepresented. Push-up. Next para. The reason for the delay in filing the appeal of about 23 days, as stated in the condonation application, is primarily that there was a delay in obtaining the certified copy of the impugned decree due to no latches on the part of the defendant stroke appellants, since it was the plaintiff stroke respondent number 1. Plaintiff is the respondent number 1.
Yes, lordship. Respondent number.
Plaintiff stroke respondent number 1 who did not put in the requisite stamp duty in order to draw up such decree. Push up next para. Thus, sufficient explanation has been furnished for the delay in preferring the appeal. Accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring FAT 19 of 2025, no arrest to cost. What is the appeal against?
My lord, appeal, my lord, I am not aggrieved by the preliminary decree. It's a partition suit between the brothers and sisters.
Then?
Now, my lord, yes, your lordship. My lord, I am aggrieved by the final decree because, my lord, the share which has been.
No, this
my-
appeal is against the final decree.
Yes, your lordship.
What is the application for? There is no connected interlocutory application?
My
Can
lord,
two
application can 2 is the application for
Stay.
stay. Lordship kindly comes to page 37 to 39. That is the, my lord, the decree in the final form.
What is your grievance?
My lord, my grievance
Allocation.
is, my lord, yes, your lordship. Order to, my lord, the Amin Commission was appointed. My lord, the report has been filed by the Amin
No, what is the
Commission.
grievance? You are in possession that has been allocated to them.
Been altered, my lord. My possession is given in such a place which is a vacant place.
The present appeal has been preferred against, regarding stay application, you have also served.
Yes, my lord. Everything I said.
Very good. The present appeal arises out of a final degree of partition. Push up. The grievance of the appellant is primarily in respect of allocation by the partition commissioner, which was made a part of the final decree, whereby, inter alia, the existing position of the parties has been seriously disturbed. Push up. Next para. In view of several questions of both fact and law being involved in the appeal, there is a prima facie case for grant of stay has been made out. Accordingly, can 2 of 2026 is allowed, thereby passing an order of stay of operation of the judgment and decree impugned in FAT 19 of 2025 till disposal of the appeal. Full stop. Next para. Judgment and decree na kore eta detail ta diye dichi. The stay of operation of the impugned judgment and decree dated April 18, 2022, passed by the learned civil judge, senior division Shodor at Kuch Bihar in title suit number 42 of 2020 till disposal of the appeal. So next para. The appellants shall put in postal cost and requisite for all the respondents because partitions. Postal costs and requisites within a week from date for service of notice of the appeal on the plaintiff stroke respondent number 1 as well as the defendant numbers 1 and 2 stroke pro forma respondent numbers 2 and 3. So next para. The trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Push up. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I am grateful, Lord. Grateful.
Number 41.
41
My lords,
lordship, one
item
for
number-
the respondent.
I'm for the
defendant
appellant.
number
I'm led by senior advocate Mr. Rai. My lords,
Which Mr.
Omolish Rai. Kindly take it up on Thursday, my lords.
Yes, Ms. Sihanovic, you have difficult. On the prayer of the appellant, let the matter stand adjourned till June 11, 2026. Give
Great.
only your name, Mr. Mittal,
Grateful.
because he's not there today.
Grateful.
And your name, sir.
Yes.
Yes.
Item number 42.
কত আছে?
Not today.
My lord,
You asking for not today?
not this week, lordship, because
Not this
Mr.
week, actually.
Sheikh will
Not
appear.
this week, not this week.
Item number 43.
Yes, Lordship. In this matter, I am on behalf of the appellant, Lordship.
What is the defect into the office report?
So for my information, Lordship, we have already cured the defect, Lordship.
Cured the defect?
Yes, Lordship.
What is the nature of the
That
defect?
is
Do you know?
not report by the department, Lordship.
Huh?
Only for report, office report, Lordship.
Office report is by the department only.
Yes, Lordship.
কি অফিস কি বলে তো ডিফেক্ট কি আছে দেখছেন yes, corrected. Regular FAT now. Deficit code fee of ₹15 has to be put in. Delay is also there. 1434 days.
Yes, Lordship.
So you have filed a section 5.
Lordship, I have to check, Lordship. The advocate on is Omid Sinha, Lordship.
Yes, you have filed a section 5 also. So you are directing to put in the deficit code fees and to serve a copy of the scan.
Lordship, already put in the deficit code fee, Lordship.
You have put in the deficit code fee.
Yes, Lordship. So for my information, Lordship.
No reflection here.
Not reflected by the department, Lordship.
There's no reflection here that it has been cured. We'll ask for a separate report from the office. We'll record your submission.
Lordship.
Then at council for the appellant submits that the deficit code fees have already been put in, which of the office shall furnish a fresh report in that regard within a week from date. Which of next para, the appellants shall serve copies of this is appearing for the first time.
Lordship.
I mean, no copy service directed previously.
Not.
The appellants shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondents, indicating that the applications shall be listed before the next appropriate bench of the next circuit. Push up an affidavit of service in that regard shall be filed on the returnable date.
Lordship, can it be Monday, Lordship?
Monday by Monday will be able to serve.
Lordship.
Just because we are directing service does not mean that we will allow it.
No, Lordship, not.
তাহলে next circuit না করে ওটা on June 15, 2026. Good. Next. Serve immediately. এই সেই সিভিল অ্যাপিল দেখো
Number 44.
দেখি ফাইলটা
I'm praying for not today.
ma'am, is it ready for hearing? Why is it appearing under the peculiar head civil appeal? We don't understand this. Let us see.
Lordship, the senior advocate is out of station.
Even if you are in station, we have to answer this question. Let us check. No. So dismissed on contest. On interim order only. It is wrongly placed in the list. First step is need not be placed in the list. Mr. Joydeepkanta Bhomik is appearing for it.
Yes, Lordship.
You tell him, he'll understand. We are directing you to passing the necessary directions. The appellant shall deposit, just check up the server copy of this order and tell it to Mr. Bhomik. The appellant shall serve, the appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent, comma, within a fortnight from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. Next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. You filed a divorce suit that was dismissed. Against that, you have preferred an appeal. There is no scope of interim order. You are the husband, no scope of alimony. Therefore, you have directed whatever was to be directed with this, deposit these costs within a fortnight. Yes, next.
Well, in 45, there is a defect, my lord.
What is the
appeal
defect?
is out of time, my lord. My lord,
great
kindly
defect.
fix it up next week, any day, my lord. I shall.
No, you have to file a
No,
second.
I'll file and serve and come back, my lord. Well, any day next week.
No, you cannot serve and come back. Before it's filed, we cannot direct you to serve. You file it and mention it.
Let
It
me
goes
cure
out
the
of the
defects,
list.
my lord.
Whenever you file it,
Kindly direct me to cure the defects within a week, my lord.
you have to file an application. There are other defects also.
Only one defect. Out of time.
2376 days anyway. No, appellants do not find place in the cost. You check up the defects. The appellant shall, the learned advocate, on the prayer of the learned advocate for the appellant, comma, the learned advocate is directed to cure the defects as pointed out by the stamp reporter within a week from date. Full let the matter be listed next on June 15, 2026. Under the heading to be mentioned. Under the heading to be mentioned. If you file an application, we'll direct you to cure the defects and then come back if you have not cured the defects. Dipankar to be mentioned. Kintu. Next.
Item number 46. Item 46, my lords, I'm praying for a day's accommodation.
Hi, move
My
the matter. You are
no,
competent enough.
My senior, Mr. Vikramaditya Ghosh, is out of station today, my lord.
Not this week,
He is before the Supreme Court today. He had a matter.
Supreme Court, he will return what depending on his the fate of the matter.
He will return today, my lords.
Even if he loses, he will return today. Well, we'll keep it tomorrow.
My lord, the state is a party, my lord. So
The state is a party.
When should you keep it? Tell us.
Thursday, my lord, if it is.
You're the AGP now.
No, my lord, I don't even have the, no, I don't know whether the briefs have been returned.
You are now glorifying the Hello portal of the AGP. So you have to tell us when you.
My lord, Monday, if it is convenient to your lordships.
On the prayer of the state, let the matter stand adjourned till June 15, 2026.
Great.
Come. Huh? Oh, sorry. Next.
Lordship, in this matter, I am praying for a day's accommodation.
Granted. Not today.
My lords, may kindly fix it for next week. State is
Why? State.
state.
On the prayer of the state, the matter will be, the matter is adjourned till June 15, 2026. State is the magic word now. Yes.
Next also, my lords.
Next also, same. Same. You are for the appellant?
No.
Oh. Same word. সবই তো স্ট্রিট দেখছি ওহো এগুলো সবই ইউনিয়ন আছে ইউনিয়নটা ধরবো
Item number 49.
Lordship, I am for the Union of India.
I'm praying for a day's accommodation.
Lordship, from
the
from 3 last circuits, they are taking the adjournment. This is the case of the audit by the GST department, and they are putting hurdles and to conduct the audits. So either because if the limitation is crossed, so doing the audit of the no use. So Lordship, I am just last 3 orders. I am just
no need not. You're submitting.
so that's why the matter should be heard immediately, Lordship. Otherwise, there will of the revenue department.
Tomorrow, this matter will appear under the heading specially fixed.
Lordship.
Just tell Mr. Ghosh that he must come prepared in this matter at least. An adjournment is sought on behalf of the appellant, Full Learned Counsel appearing for the Union of India submits that the matter has been adjourned on several occasions previously and there is extreme urgency in the matter. Full next para, keeping in view such submission, comma, we direct the matter to be listed tomorrow under the heading specially fixed matters.
Lord, deeply obliged.
Give your appearance, please. Your appearance. Yes, minus Mr. Ghosh.
Item number 50.
Your Lordship, I'm Mr.
Make your
Shah,
prayer quickly.
Mr. Shah is appearing this matter. Kindly fix it on day after tomorrow.
My lord, in this matter, state is a party. Kindly fix it.
Magic word.
Service. Service is pending, that is the.
On the prayer of the state, let the matter stand adjourned till June 15, 2026. But next week, we won't grant time to state, whoever is appearing for the state. Yes.
Next matter also, my lord, same.
Next matter also same.
Whether service is affected or not.
The service has been affected, but
Service.
Next matter is also, which, next matter, call karo. We are not recording any order, we are putting it next week then.
next to no.
Tomorrow?
Day after tomorrow.
Day after tomorrow?
51.
My lord,
State is
kindly-
appearing,
Yes,
same
state
thing.
is a party, yes.
Next week, the next week. Yeah, order record, order speaker. 50-51, next week.
Again, number 52.
Madam for the applicant.
Where is the respondent? Catch hold of the.
Kindly takes the order dated
Respondent
9/4,
coming. Yes.
2025.
Come slowly. You are appearing.
Yes, your lordship.
You are also appearing. What's it? Yes.
If my lord looks at the order dated 9/4/2026.
Let us have the bill. Paper books are not prepared.
All prepared, my lord. My lord, it has been heard by 3 circuits.
Very good. Paper book lo dao. Paper book se paper book aage de de. Hearing it time though. My learned brother has bail. His bail anticipated. Bail. So second half will be sitting singly.
And it can be taken up tomorrow.
Tomorrow will
Because
take.
my lord, there is no time today. Because it's
We have
very
1 minute left. So we are rising today. We will taken up. No use in half a minute. We can't take up anything. So we'll continue with this tomorrow.
Tomorrow.
Second half will be sitting singly. Please come back tomorrow.
My lord, one matter, the item number 67 appearing in the today's list.
Yes.
It is hit under the heading hearing. The paper book is not ready yet, and the file is here. If the matter goes out of list, I can prepare the paper book. Because I have
Inform
to
your other
update
side
copy.
and mention. Tomorrow morning mention it. Intimate the other
Other
side.
side was there, and they have no objection. They said already.
No, just bring them at the mentioning hour tomorrow. We'll do that. We'll do that. Otherwise, again, a complaint will be made and you will be embarrassed. So you'll sit singly in the second half. Hello. Yes. Call.
Number 1.
Pardon? So we'll keep it next week? You have sent? Well, learned counsel for the appellant submit. What is this application under? Acha. The learned counsel for the petitioner submits that the service on the respondent is not yet complete. Push-up accordingly, let the matter stand adjourned till June 15, 2026.
Item number 2.
To Vikas Saha. Not today.
Perhaps there has been a resolution.
Stop 3:30.
No, from 2 p.m.
2 p.m.
This has been.
Oh, acha. Thank you. Daud.
ইন্টার্ন আছে কোর্টে রাখবে
Advocate.
Mr. Iralji, yes. Very well. If both parties are not present, we'll just call the list for a few minutes for arrangement of if some date is sought or something like that. Yes. Call Kurja.
Item number 3.
Not today, by default. Not.
Three, I am there, Milad.
Yes, Mr. Dasgupta, you are appearing.
Yes, Milad. If Milad kindly keeps it on 11th instead of tomorrow or day after, Milad, I have something praying. 11th.
You are for the petitioner?
No, I am for
You
the
are for the
Milad
petitioner?
opposite party, Milad. Milad,
No, that will be an adverse order.
somebody.
That will be an adverse order for the petitioner.
Your Lordship,
No,
I am
no,
for the.
just not today. No order today.
Milad,
Just not today.
No, somebody's appearing virtually, Milad. I just saw.
Your Lordship.
Yes,
Mr. Banerjee
Mr.
will be
Srikant Chambria is appearing. He is appearing, Milad.
Acha.
His junior is appearing.
Yes, if he agrees, then we'll keep it on 11th. Yes, Mr. Cham, whoever is appearing, we can't see you. Mr.
Your
Chamble,
Honor,
yes. Should we keep it on 11th?
Your Lordship, may I please for short pass over, Your Lordship?
No, petitioner, opposite party is asking for 11th.
Can it be on 11th? I'm asking for praying for that.
All this will appear on 11th.
Very good. Very good. Obliged.
Yes. Dakota.
Number 4.
Order হবে না এমনি Yes.
I'm for the petition.
Appearing for the first time?
First time.
Well, yes.
Lordship, honestly,
Nothing in the matter.
I don't have
What
very
is
much
that?
case, but the reason I have accepted this brief is, Lordship,
Yes.
this petitioner has been misguided by my colleague. That is the thing. If I can place, Lordship, actually this is an application at 227 against an application under order 41 rule 27. I know that's
No, order 27 is not appealable.
227 we have filed, Lordship.
Yes, so what is the difficulty?
No, it's not that. I know the order 41 rule 27, if it is rejected, so courts are a little bit.
No, not that. Let us
May I
see.
place my case, Lordship?
No, but it should have been taken at the final hearing of the appeal. Let us see the impugned order once.
Lordship, the impugned order is, Lordship, at PH.
The certified copy.
Lordship, sir, certificate copy is there. 250. No, certificate copy also is certificate.
Eviction degree is challenged in that appeal.
Lordship.
What would you like to exhibit those for?
Lordship, now, we have a series of documents, that is the tenancy. It was extended from.
No, trial court held that you were not a tenant.
No, Lordship. The documents were not marked as exhibit.
No, trial court came to the finding that you were not a tenant.
No, I'm the owner, Lordship.
Acha, you are the plaintiff in
I'm
this.
the plaintiff in that.
Your suit was dismissed. On what ground? I mean,
Lordship, as because those documents were not exhibit, you were marked X and Y for identification.
no, then you have a good case. Why do you say that? Serve copy and come back. We'll
Lordship.
stay the further proceedings of the appeal.
Great.
The present revisional application has been filed against an order whereby an application under Order 41 Rule 27 of the Code of Civil Procedure by the appellant stroke revisionist petitioner was dismissed. Full stop. The short backdrop of the case is that the suit filed by the plaintiff stroke appellant for eviction of the respondent was dismissed, inter alia, with the observation that the plaintiff failed to prove relevant documents such as the tenancy agreement, written undertaking, etc. Puts up next para. It is those very documents, the originals of which were sought to be produced as additional evidence before the first appellate court. Puts up, it prima facie appears from the impugned order that the learned first appellate judge, instead of adopting the usual procedure of taking up the application for production of additional evidence at the along with the hearing of the appeal, pre-decided the same, that too, in a cryptic manner without adverting to the grounds made out therein. First up, the revisional application is thus required to be heard on the above question. The petitioner shall serve a copy of CO 68 of 2026 on the opposite party, indicating that the matter shall be listed next for contested hearing in the next circuit. For sub next para, an affidavit of service to that effect shall be filed by the petitioner on the returnable date. There shall be stay of all further proceedings in title appeal number 6 of 2023 pending before the learned additional district judge, Alipurduar, till disposal of the revisional application.
Okay, one indulgence, Lordship. Original were deposited in court, but those were not exhibited, only X and Y for identification.
Very well, yes.
Kindly comes to page 28, Lordship, without any objection from the other side.
একবার মেকে না এই কি বললাম একটু বলুন কোশ্চেনটা যেখানে ফর্মুলেট করলাম ব্যাকড্রপ অফ দ্য কেস এর পর ওরম জায়গা থেকে না দরকার নেই এরকম জায়গা থেকে বলুন হ্যাঁ হ্যাঁ না এইখানটা তার একটু আগে the originals
which were sought to produce the additional evidence before the court.
Yes, you sought to produce the originals before the affidavit.
Originals were already marked X and Y for identification without any objection from the other side.
Contractor, stop the furthermore. Furthermore, the appellant stroke revisionist petitioner submitted the said documents in original before the trial court, and those were not objected to by the defendant stroke respondent, despite which those were not marked as exhibits.
Grateful, Lordship.
The rest remains.
Grateful.
Thank you.
Deeply obliged, Lordship.
ওটা ওখানে ঢুকিয়ে দেবেন আমি ঠিক আছে ওকে থ্যাংক ইউ নেক্সট
Number 5. Item number 5, I'm appearing for the petitioner.
And for the
Well,
respondent.
the petitioner and the respondents, they have entered into talks of negotiation. If
next circuit. Learned counsel for the parties submit that the parties are attempting to resolve the matter amicably. So accordingly, on the prayer of the parties, let the matter stand adjourned till the next circuit in order to enable the parties to enter into an amicable settlement.
My lords, if because they have been trying to negotiate for a very long time.
Yes.
If kindly keeps it on Monday, my lords. If we cannot, we'll come back, my lords, on Monday.
The next circuit na kore adjourn till June 15, 2026.
My lords, I'm grateful. Grateful.
Give your names, both of you. Yes. Not today. Appearing, both sides are there. Then we can take up. Yes.
I'm paying for not today.
Not today then.
Mr. Ghosh is appearing on the day after.
Day after tomorrow. Day after tomorrow. Not today, not tomorrow. Order record করতে হবে না? Not today, not tomorrow.
Item number 7.
Not today.
Item number 8,
Same.
item number 9,
Not today.
item number 10,
Same.
item number 11.
Paying for not this week, service is not complete. By that time, service will be done.
We are not this week. Which order record? We are just making it not this week.
Grateful.
Thank you.
Item number 12,
12 Mila, I'm led by Mr. Vikramaditya Ghosh, Milord. He is out of
So
station.
in that event, if we kindly fixed on Wednesday, my lords.
So Wednesday?
Grateful.
It will appear on Wednesday. We are not recording anything. It will appear on Wednesday.
item number 13,
13,
my lord,
I appear
petition.
for the opposite party number 2 virtually.
Ashwat, you appeal for the response.
I am appearing for the petitioner.
Yes. Who is for the opposite party number 1? Mr. Nayak, opposite parties were represented together on the last occasion. It is recorded
No,
in
my
the
lord.
order.
I am only appearing for opposite party number 2. Possibly, my lord, it has gone down wrongly.
So that is a wrong recording then.
Yes, it's gone down
All
wrongly,
right.
my lord.
Mr.
I
Rai,
apologize, my lord.
Mr. Rai, right. Mr. Rai, one has been served previously
No, one.
because it was taken up.
Initially, they have submitted subject to correction, my lord. One is not participating in the proceedings. What happened, my lord? Initially, they appeared and we have served a copy upon him. The first thing is, my lord, plaintiff filed, the suit was filed, we filed a counterclaim along with the statement. Now, both the plaintiffs filed orders and relevant for rejection of my counterclaim. Subsequently, plaintiff number 1 filed an application that he did not sign that application and he is not willing to participate in that orders and relevant proceedings. And filed an application under 397 BNS now, my lord, previously 340. Our condition is that whether this application will be moved jointly by both the plaintiffs or by one of the plaintiffs. That is the pending for consideration. And the learned trial court, keeping that application pending, that orders and relevant will be heard first. That is the main thing of this application. If your lordship may kindly, I am drawing your attention. So far, the application filed by the plaintiff number 1.
No, but then 1 is required to be heard, Mr. Brai.
Yes, it is required to be served.
Serve record to serve on 1 and come back. Mr. Nayak, we are directing Mr. Rai to serve on 1 also.
Yeah, I don't have any difficulty, but only one problem. I'll just indicate.
Yes.
But my Order 7, Rule 11 application that I file against Mr. Roy's written statement and counterclaim, but that has been delayed from time to time. In the interregnum, what had happened was we also filed an expeditious disposal application wherein the learned the Honorable Coordinate Bench was directed to dispose of the matter within a period of 4 weeks. 4 weeks. But despite that order, what had happened was that the defendants come, there's a delay that's happening. The matter is fixed on the 19th. Well, on the last occasions when this matter had come up, on at least 5 occasions, adjournments were sought where we appeared, and even before a formal admission, we said, let a copy of this be served upon us, the CO. Now, the only difficulty is the next date of the hearing is 19th. The opposite party number 1 is not interested in the suit at all, not even in the Order 7 Rule 11 application. And by a reasoned order, my right to prosecute the Order 7 Rule 11 application has to decided, which appears to be the impugned order in this present civil revisional application. So only
So
request
1 is not a necessary party to the revision at least.
to the revisional
necessary
application.
party, but yes,
No,
as far as the
not.
revisional application is required, not required to be heard.
Not in my humble submission is not required to be heard because
Mr.
he
Rai,
has
do you agree with that? Yes, because 1 is not contesting. You also said.
May I just make one other submission, my lord, with my lord's permission? But just to quickly sum up, Mr. Roy has given a clear picture already. I'll nevertheless say it. But opposite party number 1 and 2 jointly institute the suit. Once the suit is instituted, Mr. Roy's client comes and files a counterclaim along with a written statement, or the other way around.
Yes.
So opposite party number 1 and 2, which is me and the opposite party number 1, we file an Order 7 Rule 11 application. Then both of them, because the Order 7 Rule 11 application was not being heard out in time, we file a 227 for expeditious disposal also. Now there is a direction that we get for expeditious disposal. We go back, show the trial judge the order and ask for directions. Now suddenly the opposite party number 1, which is the my co-plaintiff, he joins hands with the defendants for whatever reasons. I'll not trouble you. That. He says that he has not signed the Wakalatnama, or he's not signed the Order 7 Rule 11 application, nor has he signed the expeditious disposal application. So what we do, so there is they take steps, they file a 340 application, all of that's a separate proceeding. They also file a recalling of that order which was passed in the expeditious disposal CO. None of those are heard out. We file an application in which we say that because my right is independent of the plaintiff number one. Plaintiff number one.
Let us hear Mr. Rai. Mr. Naik, let us hear. Yes, Mr. Rai, you satisfy the court that he cannot maintain it individually also. If he can maintain it individually, irrespective of 340, yes.
Yes. Now can you turn to page 16? The plaint.
Yes.
My lord, so this is the
Both
suit
together?
filed together. Now, my lord, I am drawing document cause of action for filing of this suit.
Yes.
Kindly turn to paragraph 17, that is page 21.
Yes. Got
That
it.
subsequent to the above incident, my lord, got
Reading that.
the plaintiffs have done such and such approach. The police officer Kotwali PS for purpose of lodging a complaint against the defendants herein. That their main, but the police officer most surprisingly refused to accept the complaint of the plaintiffs on the ground of the same being a civil nature, but verbally advised the plaintiffs to obtain an order injunction against the defendants from the appropriate civil court. The plaintiffs thus in a state of helplessness, finding no other alternative to approach this landed court for filing of this suit against the defendant seeking an injunctive relief. This is for simplicity and injunction. My lord, there is no declaration of title, it is individually. Because there is joint cause of action, that is why my lord can turn to page 22, the prayer. This is a suit for injunction. Now, my lord, can I turn to my written statement. It starts from, my lord, page 43.
Yes.
I am drawing your attention to page 50. Paragraph 34.
Yes, 34.
That we are in position, not only that, we are chasing our title in some other way. And ultimately, my lord, the prayer has been made in page 53. Declaration in injunction.
Yes.
Now, on the basis of this, my lord, they filed an application under Order 711 for rejection of my counterclaim. Be as it may, my lord, the order which is now troubling the learned court below also for deciding 340 application is page 55.
Yes.
And if you lordship can turn to the application filed, page 57, based on which the order was passed, is page 57, where both the plaintiffs, Jitendra and Vinay, my lord, will file an application for expeditious disposal of Order 7, Rule 11 application. On the contrary, my lord, the application filed by the plaintiff number 1, that your lordship find as page 72.
Yes.
The relevant portion is page paragraph 4.
Yes.
Now, my lord, kindly consider when it appears that the Order 711 application not been filed by both the plaintiffs. I am not on that whether the plaintiff number 1 is or plaintiff number 2 can alone maintain this application or not. My condition is that as on this day, this application is filed by 2 persons, both the plaintiffs. Whether this application stands today can be entertained on the background that one of the signatories have said that I did not file the same. That
Why
is why
not, Mr. Rai? Even if suppose that will be decided independently, this 279 379 application will be decided independently. That will be decided independently.
Yes,
But
my lord,
even if
this is-
without the plaintiff number 1, opposite party number 2 could very well maintain that application under 711.
Then, my lord, that is why, my lord, if today the applicant as a today stands, whether the in the name of both the parties,
Yes, he can be transposed.
yes.
The other
That is why
plaintiff.
the amendment to be carried forward, he can be placed before the opposite party and he can maintain.
So how are you aggrieved by the impugned order? What has been done
No,
by the
my
impugned order? 711 has been
application
fixed for
was
hearing.
68, my application, we just turned down.
Proceed with the case ex parte against the plaintiff. Which plaintiff?
The plaintiffs of the petition.
No, no, that is, the impugned order is 21st of November 2025. That is the impugned order in the present CO.
That is prior to that application, Mr. Rai.
Yes. No, 2nd August
No, no,
2025. The impugned order is
Second
21st
August 2025 is the
2025.
impugned order.
Yes.
Huh?
No, that is for a
21st
different.
November.
Mr. Naik, Mr. Naik, please. Mr. Naik, please. Yes, Mr. Rai, which is the impugned order?
21st November 2025.
That is prior to that application you are pointing out.
Yes, because according to us, there is no proper written statement, objection to orders, my application counterclaim. Because when parties did not say that I am not subscribing my signature in respect of the document, whether the documents can be treated as a valid in the eye of law.
Mr. Rai, plaintiff number 2 has been allowed to pursue the petition under 711.
No, my lord, that is, it is not the plaintiff number 2, both the plaintiffs. That is why, my lord, if you lordship can turn to the
No,
application,
by the impugned
for-
order.
By the impugned order. Now, my lord, whether both the applicants have filed the application, whether it can be segregated.
Mr. Rai, both the plaintiffs filed order 7 rule 11 to your counterclaim together. They filed an expeditious hearing application together, obtained an order. Let us suppose that expeditious hearing order goes. Even then, their 711 was filed by both of them. One challenges that order 7 rule 11 was filed by only plaintiff number 1.
It is the case. That is why one can turn to the application filed by the plaintiff number 2.
But it's the order 7 rule 11.
Yes.
Show me the order 7 rule 11 application. Mr. Rai, show me the order 7 rule 11 application.
Yes, my lord.
Which page? Yes, Mr.
Order
Naik,
7.
which page? Order 7 rule 11?
Page 27, my lord. It starts on page 23. 25. And relevant portion is page 27.
Both plaintiffs filed together.
Yes. Now, my lord, can you consider?
So now one has been granted leave to proceed individually. What is the difficulty there? 340 will be heard independently, 379.
Yes. Page 72, the plaintiff number 1 said I did not file this order 7 rule 11 application. That is the contention.
Understood. So that would be at best 379, section 379.
Yes, that is what I have drawn.
That will be decided. That's on a different footing, Mr. Rai. Suppose if it is ultimately found out that he did not sign that, that does not deter the other plaintiff to proceed on a standalone footing with this order 7 rule 11 application.
So,
order 7 rule 11 is to point out to the court that it should be rejected on the face of it. Let that be decided. I don't find any illegality in the impugned order dated 21st of November. What is the illegality? 2 has been permitted to proceed independently. 7 is independently, obviously.
7 respective fact whether the court has to go into the mentality of the suit privacy if it is.
No, I don't understand the ground of your challenge to this order still now.
Order is only on the ground that whether this application as it stands today, as it made, the application made by both the parties. If one of the parties coming forward and say I did not file that application, whether this application can be considered for the purpose of adjudication without deciding.
Sir, I'll modify the order. I'll modify the order. Direct the plaintiff number 1 to be transposed in the application as pro forma opposite party. But still, this order remains. The present order, the present revisional application has been filed by the plaintiffs in a suit for permanent injunction First by the impugned order, a joint application filed by both the defendants. Oh, sorry, you are the defendants. Mr. Rai is the defendant.
Only 6, 8, and 11. Defendant number 6, 8, and 11.
Sorry. The present revisional application has been filed by some of the defendants in a suit for permanent injunction filed jointly by the plaintiffs stroke opposite party numbers 1 and 2. In connection with the said suit, a counterclaim was filed by the present revisionist petitioners. The plaintiff stroke opposite parties jointly filed an application under Order 7, Rule 11 of the Code of Civil Procedure for rejection of the said counterclaim. In view of the perceived delay in disposal of the same, a joint application was again filed by both the plaintiff stroke opposite parties numbers 1 and 2, seeking expeditious disposal of the same. An order was passed in connection with the said application. Next para, subsequently, however, the plaintiff stroke opposite party the plaintiff stroke opposite party number 1 took out an application denying disowning his signature in the applications filed jointly by both the plaintiffs, both under Order 7, Rule 11 of the Code, as well as for expeditious hearing of the said application. Next para, consequentially, an application was also filed under Section 379 of the BNSS, alleging perjury on the part of the plaintiffs to opposite party number 2. Next para, learned counsel for the revisionist petitioners argues that by the impugned order, the plaintiffs to opposite party number 2 has been allowed to pursue the petition under Order 7, Rule 11 of the Code of Civil Procedure within double inverted severally, double inverted close, within bracket, intended apparently to mean independently, bracket closed, although the application was filed jointly by both the plaintiffs to opposite parties. Next para, learned counsel for the petitioners, revisionist petitioners argues that in view of the frame of the said application and the suit, the learned trial judge acted without jurisdiction in so permitting the plaintiff stroke opposite party number 2 to individually pursue the application for rejection of plaint, which was filed jointly by both the plaintiffs, which factum has also been denied by the opposite party number 1. Next para, learned counsel appearing for the respondent plaintiff stroke opposite party number 2 contends that even independently, the opposite party number 2, being one of the plaintiffs, is entitled to take out an application under Order 7, Rule 11 of the Code of Civil Procedure. As such, irrespective of the outcome of the application under Section 379 BNSS, there is no bar to the court permitting the opposite party number 2 solely to proceed with the rejection of plaint application. Next para, upon hearing learned counsel for the parties, this court is of the opinion that there is substance in the contention of opposite party number 2, inasmuch as even independently, on his own footing as a plaintiff in the suit, opposite party number 2 is entitled to take out an application for rejection of the plaint. Next para, even if ultimately the Section 379, BNSS application is decided in the affirmative within bracket without holding so at this stage, bracket closed, it would not be a bar to opposite party number 2 independently proceeding with the application for rejection of plaint. In view of the technical objection raised by the revisionist petitioners, however, it would be more appropriate for the learned trial judge, before permitting the opposite party number 2 solely to proceed with the joint application for rejection of plaint, to transpose the plaintiffs to opposite party number 2, opposite party number 1 in the category of opposite party in the said application, comma, in view of the express intention of the opposite party number 1 to disown the said application. Full stop, next para. Accordingly, comma, CO number 33 of 2026 is disposed of by modifying the impugned order bearing order number 27 dated November 21, 2025, passed by the learned civil judge within bracket junior division, bracket close at Jalpaiguri in TS 540 in title suit number 542 of 2022 within bracket R, bracket closed, to the limited extent that the opposite party number, the plaintiff stroke opposite party number 1 shall be transposed to the category of pro forma opposite party number 2 in the application initially filed by both the plaintiffs under Order 7 Rule 11 of the Code of Civil Procedure in the trial code. Push up, the necessary consequential correction to the cause title of the said application in consonance with the above direction shall be carried out by the office, by the concerned office of the trial court at the earliest. Full stop, next para. It is made clear that the rest of the impugned order, comma, directing the application under Order 7 Rule 11 to be taken up for hearing at the behest of the opposite party number 2 solely and independently is not interfered with, and the learned trial judge, comma, it is expected, comma, shall dispose of the said application independently of the outcome of the other application under section 379, comma, BNSS preferred in connection with the self-same suit. Full stop, no address to cause, urgent certified copies.
Only
Thank
one
you.
thing, my lord. Only one small indulgence, my lord. In fact, two. My lord, the first is your lordship has recorded, my lord, that the transposition will take place prior to entertaining and hearing my application. But as a matter of fact, my lord, the hearing has already commenced. In fact, we have already concluded our submissions. So, my lord, if
No,
on the
I've not said prior to or anything like that. It will be carried out by the department in the office.
only
And the
one.
rest of the order is not complete.
Very well. But only one other thing, my lord, considering, my lord, at the risk of possibly being admonished also, my lord, my 711 application is pending for the last 1.5 years. Could also get one sentence, my lordship, directing them to expeditiously as much as possible. My lord. Next date is fixed on the 19th. We have concluded our
Again, it is
submissions.
expected that it will be dissolved as expeditiously as possible. It's not like that much. Yes.
I'm grateful.
Thank you. Thank you. Next man.
Number 14. Lord, I am on behalf of the respondent. My lord,
No adverse order,
kindly-
bar
kindly-
resolution.
kindly fixed
Why? Come back tomorrow.
next week, my
Tomorrow, come back. What is it?
my lord, I have some problem.
No problem. You'll be coming to court.
My lord,
What problem?
kindly fixed.
An adjournment is sought by the petitioner, Fusab Learned Counsel for the opposite party, seeks the matter to be adjourned till next week. Fusab accordingly let the matter be listed next on June 15, 2026.
Grateful, my lord.
Thank you. Give your appearances, both of you, please.
Number 15.
No caveat. No caveat. Contested application. Then we'll take it up tomorrow. Tomorrow. There was no adverse order that. Come back tomorrow. Yes. Keep the service with you.
Again, number 16.
Not today.
Again, number 17.
I'm for the petition of Lord.
Yes, Mr. Chaudhary. Yes.
Lord, this civil judicial application, Lord, arises out, Lord, from a judgment passed by the National Consumer Dispute Redressal Commission. Lord, the facts in brief is that in 2016 there was a burglary in the bank. Lord, I had a locker in the bank.
So there's a provision. Take a chance before the next circuit. There's a provision. Why challenge before the High Court under 226, 227?
Lord, the Supreme Court, Lord, has there is a judgment of the Honorable Supreme Court which says that, Lord, the judgment of the Honorable National.
Oh, this is against what?
Against order of National Commission.
Oh, then.
Yes.
Yes.
So,
Please
Lord,
continue. Burglary. Yes.
Yes.
Start from burglary. Again.
Yes, Lord, 2016 the bank burglary, Lord, happened. Lord, I had a locker in the bank, Lord, and all my jewelries, Lord, my valuable articles, Lord, were stolen by the burglars. Now, my
Yes.
lord, I approached the district consumer.
Mr. Dhar is for the burglars.
No, I am
No,
for the bank.
4 and 5 bank is one. Oh, 4 and 5 are their officials. There.
Yes.
So why only 4 and 5, not one?
I'm happy for all.
All. Recorded on the last. Anyway. So burglary, your locker gone,
Yes.
everything gone. Yes.
So,
Then.
Lord, I approached the district consumer forum. Lord, the district consumer forum awarded me, Lord, 59,49,300 along with compensation, cost of litigation, everything. Lord, that order was assailed before the Honorable State Commission by the bank. Lord, the Honorable State Commission, Lord, sorry, Lord, I stand corrected. It was not district commission. The first
instance state.
Yes,
Right.
state commission.
Then national.
Then national, Lord, the national commission did what? They say that the valuation of the jewelries, Lord, has not been properly done, and the valuation has to be done by a civil court. However, they acknowledges, Lord, there is deficiency in service by the bank.
Civil court will do the valuation.
Yes. This is the, Lord, this is the
Let us
judgment.
see the judge.
No, not the.
No, we'll see from the judgment.
They had before the state commission, they had filed a report of the their chartered accountants in that
Chartered valuer.
value of the jewelry.
Right.
The national, it was the state commission directed us to pay that amount. We challenged that before the
National.
commission, stating that what was in the vault or at all, it was 50 jewelry worth rupees 59 lakhs, or who knows that. That has to be decided if the court directs us to pay compensation with regard to the loss of gold. That has to be done by way of evidence. The suit court is the appropriate authority. If your lordship,
It's a deficiency of service, then
for deficiency of service, this 5 lakh cost has been imposed on us.
so that you're
Against that, we will be also filing a revisional application.
pay that and then file revision. Deficiency of service first compensate.
No, we will do that.
What will?
We will do that. But with regard to the 53 lakhs,
Mr. Chaudhary. Understood, yes. Yes, Mr. Chaudhary, he has a point there. Mr. Dhar has a point there. I mean, regarding this compensation and damage deficiency of service is something.
Your lordship takes
Now, Lord,
paragraph
if,
number 13 of
Lord,
the
the question is,
Let him finish then. Let's take it.
the
Yes.
question is, Lord, I had kept my valuable articles in the locker.
Hmm.
Now, my lord, all the valuable articles, gold articles, my lord, I have kept, my lord, the valid GST bill, valid original bill. All those purchase invoices, my lord, were placed. My lord, of valuer, my lord, has assessed all the articles, and at the prevailing rate at that point in time, my lord, in view of that, my lord, that report was prepared by the valuer. The same report was placed before the state commission, and the state commission, my lord, after being satisfied with the valuation report, my lord, the state commission has passed the award, my lord, in my favor.
Let us see the relevant portion of the impugned order first, then we'll go back to that.
Yes.
So there's no dispute that those ornaments were there in the locker.
No, we are disputing that.
That is also disputed.
They are disputing that. Now, my lord, from para 13 onwards,
Yes.
page, it is a certified copy.
Yes. I'm following that.
Either it is 13, para 13.
Mr. Dhar, lunch is over. Take your seat. Yes.
Yes. Lord, I read it for your lordship. It is undisputed that the said burglary occurred in the bank's premises, and the complainant's evidence points to multiple security lapses. The bank failed to rebut allegations regarding the condition of the vault, CCTV functionality, presence of night guards, or adequacy of alarms. The bank's defense that it had no knowledge of the locker contents and therefore no bailment existed is unpersuasive in light of Amitabh Dasgupta Supra, which clarifies that the bank's liability is not dependent on disclosure of locker contents, but on the bank's duty to maintain security of its premises and locker facility. However, while the RBI guidelines impose certain affirmative obligations on banks, the main issue in that was with respect to operation of lockers by the banks and the allottees and liabilities. In the present case, the matter pertains to banks' failure to ensure adequate security, which constitutes deficiency in service. The expert valuation filed by the complainants, although unilateral, was not effectively challenged by the OP. In view of the foregoing, the appellant bank failed to resist the allegation that it had taken all reasonable precautions and complied with mandatory security standards. It is an admitted position that the bank did not provide for any guard to secure the premises during non-working hours. The burglary undisputedly
There was no
occurred.
security guard during non-working hours?
Yes.
Great. Yes.
The burglary undisputedly occurred during non-working hours and the OP bank failed to secure the premises. The alleged loss of goods clearly did not result from any force majeure conditions, but from the negligence of the bank in taking requisite security measures, resulting in burglary during non-working hours without much resistance. The assertion that the complainant never contended security issues in the past is entirely untenable. It is entirely the role and responsibility of the OP bank to take requisite steps to protect the assets held by it in trust against such offences. OP bank clearly failed in the same and thus gross deficiency in services manifest. Under Consumer Protection Act, the claim for compensation needs to be reasonably established by the complainant. As regards the compensation claim, the evidence adduced by the complainants included an expert valuation of the stolen items, which were reported immediately by the complainant after the incident. This is, however, unilateral with limited scope of the OP bank to rebut. While it may be a fact that the complainant possessed the articles listed in the expert valuation, it cannot be concluded that these articles have in fact been kept in the OP bank locker in question. It is also undisputed that such keeping of the articles in the bank locker is personal to the complainants and the bank has limited role in monitoring these actions, other than facilitating the operation of the locker. Therefore, in the present case, while the breaking open of the locker by the burglars due to the bank's failure to secure its premises is established, the quantum of loss suffered by the complainants needs independent determination. As regards the determination of compensation in such cases, the Honorable Supreme Court in Amitabh Dasgupta versus United Bank of India and others, civil appeal number so and so, considered that in such cases where the valuables of the complainants were stolen from bank locker, the consumer fora ought not to award the value of such stolen articles, which may not be properly assessed for lack of detailed evidence, as might be led in civil courts. Since the procedure to be followed in the consumer fora is summary in nature, the relevant observation of the Supreme Court are as below. Lord, then it has been set out. Lord,
Let us read this point. This is relevant. Yes.
As discussed, supra, imposition of liability upon the bank with respect to the contents of the locker is dependent upon provision and appreciation of evidence in a civil suit for such purpose. However, this does not mean the appellant in present case is left without any remedy. Banks as service providers under the earlier Consumer Protection Act 1986, as well as the newly enacted Consumer Protection Act 2019, weigh a separate duty to care to exercise due diligence in maintaining and operating their locker or safety deposit systems. This includes ensuring the proper functioning of the locker system, guarding against unauthorized access to the lockers, and providing appropriate safeguards against theft and robbery. This duty of care is to be exercised irrespective of the application of the laws of bailment or any other legal liability regime to the contents of the locker. The banks as custodians of public property cannot leave the customers in the lurch merely by claiming ignorance of the contents of the lockers. In view of the foregoing, while the quantum of compensation liable to be paid by the OP for the loss suffered by the complainants requires to be determined by a competent civil court, it is evident that the OP bank is deficient in its service in failing to ensure adequate security of the bank locker.
No, but Mr. Chaudhary, this is in line with the Supreme Court judgment. The portion quoted, because here it has been segregated between two, the liability of the bank, deficiency of service, and that has been granted to you 5 lakh, and liberty has been given because that is a matter of evidence. This is of a summary nature. That was precisely what was held in this Amitabh Dasgupta's case. So what is wrong in this?
I will let the question.
RBI also saying the same. Your Honor, RBI is also saying the same.
Who are you?
He is in the matter. On behalf of
no, one, I can hear only one.
Milord, the RBI guidelines, Milord, says that a bank is liable for the loss of articles kept in the locker with the bank. The bank cannot contract out of its responsibilities in relation to a locker by describing the agreement as that between a landlord and a tenant. When locker was found emptied and contents lost, the banks have been held liable for deficiency in service. However, in some such cases, these disputes were left open to be decided by civil court after taking detailed evidence.
Exactly.
Both are separate. But
give a copy of this.
With respect of money.
Irrespective of your reading out aloud, I'll read it. Now, once I've got Mrs. Dhar has got the scent of blood and food, so you rely on that.
not food.
Not food for thought, at least.
I mean, the question here is
no, don't suppress that.
No.
Say RBI guidelines are sacrosanct. There's a reason you have been briefed, Mr. Chaudhary. So what is?
My lord, problem here is, my lord, this loss, my lord, how this loss will be computed, my lord, the valuation.
এটা
will be
ফেরত দিই, এটা
computed.
ফেরত
My lord, this-
সাইড না করলে তো-
because there was a, my lord, valuation by a chartered accountant, my lord, with respect to all the bills.
No,
The
this
end-
requires evidence, Mr. Chaudhary. National, for a change, he's correct.
My lord, can I come back tomorrow?
No,
with-
don't
with-
come.
with better-
Come back tomorrow with a better case. Not this. No. The present challenge has been preferred against a judgment whereby the National Commission, the National Consumer Disputes Redressal.
But, like my learned friend is willing to say something that if your lordship grants him leave, my lord, he can, because
Verily, yes. What do you say? You are relying on that. Give a copy.
Lord, this is his internal notes. Internal notes.
No,
He wants to make a submission.
Yes, absolutely, yes.
Your Honor, Supreme Court has said the consumer fora can award actual compensation equivalent to actual loss in case of deficiency in such. Actual loss, but in
So please cite that judgment. What was judgment?
judgment also it is given.
Mr. Chaudhary, come back tomorrow with all these judgments. Amitabh Chaudhary, bring sufficient copies of Amitabh Chaudhary for the court as well as Mr. Dhar and these judgments, whatever learned. Mr. Dhar, give advance copies to him so that he can come.
I'll give.
Should we keep it tomorrow?
I'll give it by evening, my lord.
During arguments, it transpires that learned counsel for the petitioners seek to rely on certain judgments. Full sub next para, in order to enable the opposite parties to come prepared on the same, let advance copies of those be served on the learned advocate for the opposite parties during the course of the day. Full stop. The matter shall be listed tomorrow under the same heading.
I'm great.
Thank you.
Number 18.
Not. You happening?
Yes.
Other side, no caveat.
No, I pay for 1 day accommodation.
Good. Not.
And number 19.
Same.
Contested matter? No, contested matter.
Who is contesting?
18.
If other side is not there, your resolution is there.
Yes.
Either resolution or other side. So not today then only. Yes. Come back tomorrow. If they're not there, we'll take it.
19.
Lordship, in this matter, Lordship, as per the last direction, I have served copy upon the respondent.
No, but we don't know whether they're appearing. So come back tomorrow.
Lordship, Friday, Lordship.
Friday? তাহলে Friday করে দাও, এটা হচ্ছে 12th June.
Grateful, Lordship.
Item number 20.
Lord, I'm appealing for the petitioner wife, your lordship. This is the application of section 24 of transfer of matrimonial.
There is no other side till now.
I am appearing.
Oh, you're appearing. Why are you hiding behind him?
No.
Yes. Divorce suit filed by husband.
From the Court of District Judge Jalpaiguri to the additional learned additional district and session judge Mathamang, Coach Bihar.
You reside in Kuch Bihar.
No, my lord, district Coach Bihar, but Mathavanga, your lord.
You reside at Mathabhanga.
District Coach Bihar.
And
But Mathabhanga, there is no competent court. District court
No,
is
my lord, additional district.
additional district judge is there.
Additional district judge is there. My lord, I reside in Banarhat. Jalpaiguri is also a distance from my home, and Mathavanga is far more distance from me.
What is the difference in distance?
Mathavanga.
So it's all the same to you whether it is Jalpaiguri or Mathabhanga.
Yes, my lord, but husband, several cases have filed already.
Ajay, you complete your submission, then we'll hear him. Yes.
Yes, my lord.
Their distance from
Mr. Sarkar, you take your seat, let her complete, then we'll come back to you. Yes.
My lord, from Mathavanga.
What are the cases which he is contesting there?
My lord,
No, what are the nature of the case? 125.
yes, my lord, 125.
498A must be there.
8A, my lord, then my lord, she filed the under section 127 of CRPC, my lord.
127, 125, yes.
Then
So
my-
he has been contesting all those by going there.
Yes, my lord. Even my lord, lastly, husband filed the criminal revision, my lord, which is now pending at the Mathamanga court, my lord.
Against
my
that 127.
Yes, my lord, against the 127, challenging the 127 CRPC. So one more cases can be transferred.
No child.
One daughter has
Age?
25, my lord.
Age of daughter is 25.
Yes, my lord.
Then she cannot be a ground. So she can bring you to this place.
No, my lord, she is a student, my lord.
What do you do? Nothing, according to you?
No, my lord, no independent source of
No
income.
independent source.
Aged mother is there, my lord.
Everybody has an aged mother when there is a section 24. He will also have an aged father or something. So aged mother, distance.
My lord, there is 2.5 hours, my lord, from the Mathamanga and Jalpaiguri. By
2.5 hours is nothing.
my lord, she need.
You don't have to reside there overnight. 2.5 hours is nothing. You are not Pardhanashin or otherwise handicapped.
No, my lord. No, my lord.
And criminal cases are in different cases, in different courts. I mean, not that they can be taken up, the location may be the same, Kuch Bihar, Mathabhanga, but they will not be heard together. She may have to travel for those cases there. If it was heard together, then we could club them. There is no scope of clubbing 127 or revisional application with civil suit.
My lord, but criminal division, which is now pending, my lord, at Mathamanga court, my lord, the husband filed that case.
And he is contesting, prosecuting that. Well,
After the matrimonial suit filed by the husband, last case, which is criminal division, that is also filed by the husband. So one more case can be transferred.
criminal division is pending where? Mathabhanga itself.
Mathamanga court, my lord.
Oh, achha.
That was filed by the husband.
Right, understood. And 498A is still pending.
No, my lord.
But he contested that by going to Mathabhanga.
Yes, my lord. Challenging the one.
Achha, anything else? You complete your submission, we will go to them.
Yes, my lord.
Well, yes.
My lord, I am a clerk in a school. I have a job and I have to take
School in Banarhat.
Banarhat.
You take your seat now.
I
Yes.
have also an ailing mother.
Yeah, obviously.
My age is almost 55.
Your age?
Yes, my clients.
No, not obviously, not your mother's age.
He has a 25 years old daughter. So
She also has a 25-year-old daughter, by chance. Yes. Daughter is residing with her. How are you taking benefit of the daughter?
I am not taking that benefit, my lord. I am paying her maintenance.
What judgment did you cite on the last occasion? This Suresh Kumar Jain, what is it about? That was for that bench. For that. Very well. So go there and contest. You have already filed a revisional application. You are
My
contesting.
revisional application is there because 125 application. they have
Obviously,
filed.
but you can go there and contest. You have proved that. You contested
I
127
have
498.
traveled all along, my lord. But now my
Continue traveling for some more time till the
No,
suit
my
is
lord.
decided.
My lord, may I
Suit
submit
is at
one?
initial stage, and I am traveling from Banarhat to Jalpaiguri. My distance is from Banarhat.
65 kilometers.
My distance is from 65 kilometers.
From Mathamanga to Jalpaiguri,
And
my lord,
Mathamanga to
73
Jalpaiguri will be
kilometers.
75 kilometers. It will be
70
63 and 75. 12 kilometers more.
12 kilometers more.
65 and 73, my lord.
So
Reverse.
Yes, my lord. From
65
Banarhat,
for me, 75 for them.
yes, my
That
lord.
is the
Go there.
difference. my lord.
Go there. Go there.
No, and from Banarhat to Mathamanga, it will be almost 80 kilometers.
Huge difference. Huge difference.
No,
72 and 80.
80, my lord.
8
I-
kilometers.
I have to. I am taking travel. I have taken travel to go to Mathabanga and contested.
You have taken travel long back.
Long
Now you suffer it.
Now I am aged, my lord. Now I am aged. I am on the verge of.
What is your age?
retiring. My 57 almost. My.
Don't tell the court. No. Go there and
I am
contest.
suffering from several medical, several illness also, my lord.
Revision also filed by the husband.
If you have to come to Jalpaiguri, the same illnesses will follow you.
My lord,
No. Come, go there.
they are ground in transfer application, my lord. Kindly see, their only ground is they have no place in Jalpaiguri to reside.
No, that is a bad ground.
And
2.5 hours journey,
and
they
another,
don't require
another
a
ground
place.
is mother's illness, and another and
So you are countering that. Your mother's illness and
and another ground is that they expenses. I am ready to bear the expenses of their travel.
you are bound to 127. You have filed a divisional application.
I am paying the maintenance. It is not the maintenance is pending. I am ready to bear the expenses of traveling to Jalpaiguri. If
She
they are
she has never traveled to Jalpaiguri except to rather she is not traveling to Jalpaiguri except to contest this case. On the other hand, you have been traveling there to contest the other two criminal cases as well as filed a criminal revision.
those cases has been disposed of, my lord.
Criminal revision is pending.
Criminal revision against the 127 application.
Yes. So you are going there already. So contest the suit also there. What's the difficulty? There is only one additional district judge at Mathapanga.
Yes, my lord.
So allow me. Enough arguments. The present application under Section 24 of the Code of Civil Procedure has been filed by the petitioner wife for transfer of a divorce suit filed by the opposite party husband in the court of the learned district judge at Jalpaiguri. Push-up, learned counsel for the petitioner wife argues that the petitioner resides at Mathabhanga, where two criminal cases, respectively under three criminal cases, respectively under sections 125 and 127 of the Code of Criminal Procedure, as well as section 498A of the Indian Penal Code, were being contested by the opposite party husband. Push-up, that apart, it is submitted that the opposite party husband has also preferred a criminal revisional application in connection with the proceeding under section 127, which is also pending in a court at Mathabhanga at present. Push-up, thus, it is submitted that the opposite party husband has already been traveling to Mathabhanga to contest other litigations, and it would not be an additional burden on the opposite party to travel to Mathabhanga if the divorce suit is also transferred there. So the next para, on the other hand, it is submitted, the petitioner wife is otherwise financially indigent and also has an ailing and aged mother. Push-up, next para, moreover, that in view of the distance between Mathabhanga, where the wife resides, and the district court at Jalpaiguri, it is a transfer of the suit is sought to the court of the additional district judge at Mathabhanga, which is also competent to take up matrimonial suits. So next para, per contra, learned counsel for the opposite party husband submits that the opposite party was constrained to file the criminal revisional application at Mathabhanga, since the same was a challenge against an order passed by a court at Mathabhanga under section 127 of the Criminal Procedure Code. Push up next para, even otherwise, it is submitted that the husband is aged and has an ailing mother as well. Push up next para, moreover, it is contended that the petitioner husband is a clerk working at Banarhat, and it would be difficult for him to go all the way to Mathabhanga, which is more distant than Jalpaiguri from Banarhat, where the husband is now residing. Push up next para, upon hearing learned counsel for the parties, it transpires that the distance between the respective distances between Banarhat and Mathabhanga on the one hand, and Banarhat and Jalpaiguri on the other, is not consequential, not considerable. Push up next para. Rather, it is the opposite party husband who has not only contested all three criminal proceedings before the Mathabhanga courts, but has also taken out a criminal revisional application at a court in Mathabhanga, which the husband is very much prosecuting now. Push up next para, that apart, since the petitioner wife is suffering financial difficulties, is apparently suffering financial difficulties, for which she was constrained to take out an application under section 125 of the Code of Criminal Procedure first, and thereafter under section 127 of the code, which is now sub judice by way of a criminal revision filed by the husband, it furnishes an additional ground for transferring the suit to the court of the additional district judge at Mathabhanga, instead of retaining the same in the district court at Jalpaiguri. Full stop. Next para, by balancing the conveniences and inconveniences of the parties, comma, the ends of justice demand that the suit be transferred to Mathabhanga. Full stop. Accordingly, CO 61 of 2026 is allowed, comma, thereby directing matrimonial suit number 40 of 2023 pending before the court of the learned district judge at Jalpaiguri to be transferred to the court of the learned additional district and sessions judge at Mathabhanga, comma, district Kuch Bihar. Full stop. Next para, the learned copies of this order be communicated to both the court of the learned district judge at Jalpaiguri as well as the learned court of the additional district judge at the court of the learned additional district judge at Mathabhanga, comma, district Kuch Bihar at the earliest by the department. Full stop. Next para, the said courts shall act on the server copy of this order. Full stop. The district court at Mathabhanga shall ensure that the concerned department of the district court at Jalpaiguri shall ensure that the papers of the suit be sent at the earliest to the court of the learned additional district and sessions judge at Mathabhanga, district Kuch Bihar. No address to cause urgency.
Okay.
Thank you. Sorry, Mr. Yes. Next. Well argued. Yes. 21. Not today.
22.
Same. Appearing?
For the petitioner. Lordship, affidavit service already done.
Appearing for the opposite party? Yes.
Lordship,
Yes, what is the matter?
Kindly fix it. day
No,
after
no.
tomorrow.
After so much trouble, you have to move the matter. He
Lordship,
came running. I took up the file. Now you have to move.
Lordship, my senior counsel, Mr. HON'BLE
You
Prasad,
could have said that at the inception. What is the matter about?
matter about against the impugned order under Order 7, Rule 11, Your Honor. Kindly.
711 rejected, obviously.
Yes, yes.
On what ground? What is the suit for?
This is
Compensation.
Compensation.
Compensation because of that
Let us see the relief.
construction erected by the petitioner out here.
So in a sense, money suit.
Money suit, a kind of money.
On what ground did you ask for rejection? Let him argue. Yes.
Lordship, the valuation of the suit is jurisdictional error.
That is curable. 711 can only be attracted if court finds
Another point, my senior counsel, Mr.
on the
HON'BLE
prayer of the petitioner, let the matter stand adjourned for the day. Come back.
Milord, kindly fix on Friday.
Friday?
I can file you.
Yes.
Well, no question of AO. 711 application. Come back tomorrow. Adjourn for the day. ওটাই থাকবে. Give only your name. Yes.
Your Lordship, in item number 23.
Item 23.
23, I am for the
23, yes.
petitioner, Your Lordship.
Yes, please. You are for the petitioner, right?
Yes, Your Lordship. This is for expeditious hearing of the suit before the learned trial court.
A copy was directed to be served.
Yes, Your Lordship.
You are appearing,
we have
yes.
the copy.
Right, they are appearing. Yes, Mr. Mithuka, what is the expeditious hearing of what?
Of the suit along with application number order 26 rule 9. Application is pending since March 2025.
March 2025?
Yes, Your Lordship, March 2025 it is pending.
Acha. So, Beryl, what is the difficulty? You are opposing this? Yes, Mr. Dhar, you are opposing this?
And I there am is opposing this, but Lordship find the order that is challenged 23rd February 2026. The next date of hearing was fixed for the order 26 is on 10th June. Therefore, tomorrow is 10th June.
No, we'll direct the. What are the pending applications now?
Only this application.
Only order 26 rule 9 is pending, Mr. Mithuka.
Yes, Your Lordship, yes. Only this
You also
application
say
is
so.
pending. We have filed our objection.
Will direct that to be taken up for hearing on the next date?
Yes.
Day after tomorrow?
But
Yes.
before that, where is the delay? He should have demonstrated where is the delay.
So he's saying from 2025 it's pending?
Yes. 2025, he filed the amended application.
Amended what application?
Application of order 26 rule 9. He filed an application thereafter he rectified it by filing an amended. This was the delay. Where is the delay?
When did he file the amended application?
Application was filed on the
Use the microphone.
The amended application was filed. When was the amended application filed? Yes, Mr. Mithugi, please.
May 2025, Lordship.
May 25. So May 2025, it's pending for so long.
Hearing for, no, fixed on May 2025, it was, next date was fixed on 21st June for hearing application under Order 26 Rule 9. Thereafter.
Yes, Mr. Mithugi, when did you file the amended 26-9?
Your Lordship. On the 23rd February 2026. Your Lordship, may I be permitted to say one thing? That application under Order 26 Rule 9 was filed on 5/3/25. Then it was thereafter fixed for hearing on 21/7/2025. When the matter was.
You yourself filed an application for amendment of that application.
Yes. Your Lordship.
That was the delay.
Only one clerical mistake was there. Only one clerical mistake. That instead of Tata, Sakti.
Whatever, but due to that reason only you saw amendment. That's why the matter got delayed. So no fault of the court.
I was ready for hearing, but hearing could not completely commence, Your Lordship.
The present application has been filed for expeditious hearing of an application filed by the petitioner under 26 Rule 9 of the Code of Civil Procedure in connection with the suit is for what? Probate?
Partition. For partition.
In connection with a partition suit. Who's up next para? Learned counsel for the opposite party submits that. Which opposite party?
I'm opposite 1 and 3.
1 to 3.
1 and 3, not 2.
Opposite party numbers 1 and 3 submits that there was no fault on the part of the trial court in view of the petitioner himself having filed an application for amendment of the said application under Order 26 Rule 9 of the Code of Civil Procedure, due to which much time was consumed in the trial court. Who's up next para? Although there is directly no fault on the part of the trial court in delaying the matter, it is found from the records that the application has been pending for quite some time, full stop, even taking into account that the application was subsequently amended at the behest of the plaintiff stroke petitioner, the said amended application was filed sometime in February 2026.
23rd February
2026. Push up next para. Accordingly, it is expected that the application shall be disposed of at the earliest by the learned trial judge. So next para, at this juncture, learned counsel for the opposite party numbers 1 and 3 informs the court that the matter is next fixed on June 10.
Day after tomorrow.
June 10, 2026.
One
Yes.
indulgence, Your Lordship, one indulgence at page 96. There is an order of the Honorable Division Bench also in this matter that the suit should be heard expeditiously. Page 96. In middle portion.
So next para, although learned counsel for the petitioner also points out that there was a previous direction by a coordinate bench of this court dated December 15, 2021, passed in, by a division bench of this court in, I forgot the time in a thing. The division bench of this court dated December 15, 2021, passed in FMAT 16 of 2022 to expeditiously dispose of the suit, taking into consideration the subsequent filing of the application under Order 26 Rule 9 of the Code, the trial court cannot be faulted for the delay in the said disposal. Full stop. Next para, be that as it may, in view of the application being fixed for hearing day after tomorrow, CO 67 of 2026 is disposed of by requesting the learned trial judge to take up for hearing the pending application under Order 26 Rule 9 of the Code of Civil Procedure in connection with OC within bracket partition bracket close suit number 56 of 2019. Full stop. It is expected that the learned civil judge within bracket senior division bracket close at Siliguri shall dispose of the said application within a week from taking up the same. Full stop. Next para. Thereafter, the learned trial judge is also expected to dispose of the
suit itself as expeditiously as possible, comma, preferably within 8 months from the date, within 8 months from date. Full stop, next para, no arrest to cost, certificate.
Oblige, Your Lordship. Much obliged.
Thank you.
Appeal number 24. 24, my lords, I'm for the appellant petitioner, my lords. Can one is delay application, my lords.
Serve and come back.
I have served. Services complete.
Then we have to wait for the other side. Let us come back tomorrow. Not today.
Appeal number 25.
Same, not.
Appeal number 26.
Not today.
Lordship, in item number 26, I'm led by Mr. Saptangshu Vasu, advocate, senior advocate from Calcutta High Court. Lordship, I'm praying to fix this matter on next Monday so that he could be available here.
I am the petitioner, Lordship.
On the prayer of the opposite party, let the matter be listed on June 15, 2026. Listed next on June 15, 2026.
Lordship,
We are taking up reaching matters.
Lordship, can this matter be listed on top of the list? Because as he will be appearing from Calcutta, he will
Achha, very well.
be returning.
Under the heading specially fixed matters. Specially fixed so pura diyo Dipankar.
Much
Please come prepared on that date also. Thank you.
Appeal number 27.
Lordship, I'm for the appellant. Lordship, in this matter, can 2 is the condemnation of delay, Lordship.
You have served.
Lordship, yes.
Wait for today.
Lordship, sir, they have seeking time for filing opposition in regard to the limitation, but despite several direction, they did not.
No,
file.
today you have a resolution. That's why I am not taking up. Come back tomorrow.
In this matter, previously we appeared. Well, can you record that we have no instruction to appear in this matter anymore, Madam? I'm returning from this matter, Madam.
Oh, but your client will be sabotaged. You have to write to your client.
She is not responding to my phone calls. Anything. Not kindly. I'm returning from this matter.
Oh. Acha, ekta order record karo. At the time of call, learned counsel for the only one opposite party.
Madam.
Opposite party submits that despite repeated efforts, counsel has been unable to contact his client, that is the opposite party, neither have his calls been reciprocated by the opposite party. Full accordingly, on the prayer of learned counsel for the opposite party, counsel is permitted to retire from the matter. Full stop. Dekhi file letter.
Lordship, 58 days delay.
What is the ground? Condonation I'll allow, but I'll direct you to serve afresh the main matter.
Yes, Lordship.
Oh, it's a second appeal.
Yes.
58 days. Reason?
Lordship, collecting all the documents and communicating with me.
Not
Lordship.
collecting documents.
Certified
Medical ground,
copy,
no
Lordship.
certificate annexed.
Certificate. Ground of advocate or client?
No. Clients.
Uncontroverted, non-traverse. Perusal of the averments made in the condonation application, sufficient reasons transpire for the delay in preferring the appeal. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring SAT 13 of 2024. Let the appeal be placed tomorrow on before the division bench under the heading Order 41 Rule 11.
Lordship.
Along with the connected other application.
Lordship.
Tomorrow, Order 40.
Grateful.
Thank you. Mr. Pal, you have given your name because today it has to be recorded. For recording that you are no longer appearing, it has to be recorded. Whoever is here, recorded, yes.
Again, number 28.
28, Your Lordship, I'm for the opposite party number 1.
Yes.
The petitioner is supposed to file the affidavit in reply, Your Lordship.
Come back tomorrow. Today you have a resolution. Not today. Yes.
Okay, number 29. That's 29 minutes. Can 1 is my application for condonation of delay.
Served.
Served, madam.
Wait. Tomorrow, come back tomorrow. You're appearing?
Yes, my
My lords, we are open.
You're appearing in the matter? Oh, then we'll take up. Yes. No.
I have explained the delay, my lords, in paragraph 2 and 3, my lords.
Use the microphone so that Mr. Ghoshal can hear you.
The delay has been
And
explained in
Mr. Bhutia.
paragraph number 2 and 3, my lords, of CAN
What is the delay?
My lords, 96 days.
What are the explanations? Tell us.
My lords, the appellant is an aged lady, my lords.
What is the age? 30.
No, my lords.
Everybody calls himself aged.
My lords, she has, my lords,
40 years aged?
No, my lords.
Oh, he's the son.
He is the constituted attorney, my lords.
If constituted attorney could file this, he could conduct. Yes. Age is then not a factor.
There has been a delay of 96 days, my lords. As
Let
per
us see
my
the
lords'
reason
report.
2 and 3.
Yes, my lords.
What is the reason? I don't find it. There has to be a semblance of a reason. Now, Supreme Court is very strict in these matters. So show us the reason.
My lords, second paragraph, my lords, that she is incapable of physical movement, my lords.
Second paragraph of. Oh, actually, I was reading the other can. Which is the condonation? Can?
Can 1, man.
1. No, can 1 is stay application. In your copy, it's wrongly.
My apologies.
Can 2 is the section 5.
Apparently.
Para 2, yes, considered. Achha, for appointing the constituted attorney also you took time. That is what it was. Yes, we are allowing it, Mr. Bhutia and Mr. Ghoshal.
My lord, kindly consider the application and
Yes.
kindly consider the conduct of the respondent.
Yes. Yes.
This appeal was filed sometimes in the month of December 2025. Kindly
Right.
consider that decree was applied. Decree in this appeal, first appeal, was applied on 21/11/2024, which was received on 4/12/2024. Now they have not applied for the judgment copy of the appeal, which was applied on 26th March 2025. After the execution attempt was made, where the petitioner, where the appellant, along with her daughter, has objected to execution to that, the same. I don't think they have already also filed the judgment copy as of now. There is a defect in that file for that. So first they have to cure the defect.
No, judgment is there. This is a second appeal or first appeal?
Second appeal,
Second appeal.
What is the judgment?
Judgment of the trial court is there, which they have applied on.
No, if there's no judgment, if there's no judgment of the appeal, no, judgment is there. Judgment is there.
These defects have been cured.
No, Mr. Ghoshal, judgment is there. It's there in the record.
Now consider the
Otherwise, there would be no appeal in the eye of law. There would be no appeal in the eye of
on
law.
the last
Lord of
occasion,
You're right.
they have not filed that. My lord, kindly consider
sir.
they have willingly and deliberately delaying the matter, because they have applied for the judgment copy on 23rd March 2025. My junior friend is there, who will hand you over the copy of the order of the executing court dated 26th February 2026, from which it will transpire that appellant along with her daughter Nirjala
Give a
Subba.
copy to him. No, but whatever you are handing over to court, you should give to the other side. So you say that only after that they applied for this judgment, when you tried to evict them.
They have just filed it.
Execute.
That is also with the delay. They have formally filed it to delay the execution proceeding. And if my lord kindly considers the application itself, kindly consider the cause title. It is stated that the delay is of 983 days. There
No,
is
that has been corrected with the leave of court. Corrected with the leave of court.
no copy has been
In our
served.
copy, corrected copy should have been given to them.
Actually, it was corrected after the copy was served.
Yes, but you should give a copy.
My lord, no date.
It has been corrected with the leave of court, Mr. Ghoshal. Made into 96 days now.
Now, that explanation is of 96 days has not been explained in the application itself.
But that is as per the stamp reporter's report, my lord, 96 days.
No, the power of attorney holder is your, how is he related to you? Not related to you.
Not related.
Not.
My lord, kindly consider 96 days or whatever days, 1000 days delay can
Hmm,
be common. But as per the apex court judgments, or each and every delay has to be explained. That explanation is not there.
Yes, merely that you are aged is not a sufficient ground as such.
She was bedridden at the time, my lord.
Where do we find that?
It's paragraph 2, my lord.
No medical.
Two.
As such, my lord,
No
the word
medical given.
bedridden has been used.
No medical certificate, nothing. Bedridden, where have you stated?
But that word as such has not been stated.
No, you only say you are an aged person incapable of physical movement comfortably. So uncomfortably you can move. Comfortably,
they have
we
been
also can't
resisting
move
the
after the
execution.
entire day sitting in court. I also am not comfortably moving for a few minutes. But that's not a ground. Old age, incapability, and valid points have been taken by. Mr. Ghoshal, you just point out this instead of handing over these papers. We'll give you 1 week's time. You have file your opposition to this section 5.
Deeply obliged. Deeply obliged.
Learned counsel for the opposite party seeks to file certain documents indicating the apparent conduct of the petitioner, appellant stroke petitioner, whose it is submitted by learned counsel for the petitioner that the petitioner, due to her ailing condition and advanced years, was incapable of preferring the appeal in time, and subsequently, only upon appointing a constituted attorney, could prefer the appeal. Next parallel, counsel for the opposite party controverts such submissions and argues that from the conduct of the petitioner, it is seen that only after execution was sought to be levied in respect of the impugned decree did the appellant grow wiser and applied for the certified copy of the judgment of the first appellate court. Next para, it is submitted that that the reason for such delay in applying even for the certified copy of the impugned judgment remains unexplained. Next para, in view of the respondent stroke opposite party seeking to rely on certain documents and bring further evidence, further averments on record, leave is granted to the opposite party to file affidavit in opposition within a week from date. Reply, if any, shall be filed by. How soon can you file a reply?
Within 2 days, my lord. Within 3 days, my lord. 3 days.
Then it takes you to the next circuit. Very well. We'll grant you 1 week's time because you have time. Reply, if any, shall be filed within a week thereafter. Let the matter be listed before the appropriate bench in the next circuit.
My lord,
Mr. Ghoshal, please come to
my lord, let there be a direction upon them to serve as a corrected copy of that application.
Very well. Sorry. The learned advocate on record for the appellant shall, by tomorrow, serve a corrected copy of the condemnation application on his counterpart appearing for the respondent.
Deeply obliged.
Try to do it today itself. Yes. Thank you. Yes, next.
Item number 30. That's item 30, my lords. Can 2, my lords, is my application for leave to appeal, my lords.
Leave to appeal? Why do you require a leave? You're not a party to the trial court.
No, my lords. I'm the legal heir, my lord.
Died in the interregnum between the.
No, my lords. Before the judgment was passed. Before the first appellate court passed the judgment.
It was their appeal in the first appellate court?
Yes, my lords.
It was their appeal. So you say that it was passed in the name of a dead person? Come prepared tomorrow, come prepared tomorrow. Come properly prepared, we'll hear you on this. And even there's a resolution today, so come back tomorrow. If somebody is watching the matter, we don't know.
Item number 31.
My lord, I am for the appellant, my lord.
Yes.
At the stage, my lord, second appeal at the stage of admission under order 41 rule 11. My lord, one of the appellant, my lord, expired. So, my lord, I have filed these 3 can applications. One is for substitution, abatement, and limitation.
Swiss of copy and company.
I have soft copy.
So then wait till tomorrow then. If you have soft copy, file your opposition service tomorrow, affidavit service tomorrow. Just not today.
Again, number 32.
Not today.
My lord, the appeal has been admitted, my lord. However, the service has not been affected as of now, my lord. Can we give the?
There was a direction for service.
There was a direction for service, my lord.
So then what do you want then?
My lord, a week's time, and we hope.
Come back on Monday, next Monday.
Grateful.
You are for the appellant.
I'm for the appellant, my lord.
Sole appellant.
Yes, my lord.
Check up.
I'm on this, not my file.
At a কত number item?
32 and 33.
Oh, learned counsel for the appellant seeks an adjournment in view of service having not yet been completed. Whoso accordingly let the matter stand adjourned till June 15, 2026. Both are to be heard together. Matters. ওটা plural করে দিয়ে দুটো action. 32 and 33.
Grateful.
Thank you.
Number 34.
Not today.
Again, number 35.
33. My lordship, I am on behalf of the appellant. Service has not been yet complete.
Not complete. So when should I keep it? Tell me.
I have sent the notice, but.
Should you keep it next week to await service?
Yes. On 17th.
17th. On the prayer of the petitioner, let the matter stand adjourned till June 17, 2026.
My lordship, 35, 36. Same.
35, 36, do the same order. The same order. Same order. 17. What is the defect in the meantime? You can cure the defect. Please check up and cure the defect.
Yes.
Again, number 37.
Not true.
Again, number 38.
37 you are appealing.
Also, in this case, I am the appellant also.
37 to the.
There is a defect in you.
What is the defect?
Defect is relating to this. There has been a delay of 27 days. So
So
I haven't filed
you have filed a section 5?
No, I haven't filed. So seeking accommodation for a week.
Well, we are just making it not this week. In the meantime, file it and mention that appeal. Just making it not this week, not recording in note.
Okay.
Again, number 38.
Not today.
Again, number 39.
In item 39, service has not been completed.
Next week then? 15th, next week. Now this is June 15th. As
Again, number 40.
Okay, I am appearing on behalf of the appellant. We have served twice, but at the address provided by the claimant, we are the insurance company appellant. As per, but at the said address as mentioned in their claim petition, it has been.
We'll take it up tomorrow. I'll take it up tomorrow, and because today there's
we will serve upon the.
Now, how many times will you serve? If you have served at their address,
Yes,
then we
their
can take up the matter also maybe. Come back tomorrow because today you have a resolution. So somebody may be there.
Again, number 41.
Not true.
My lord, 41, 42.
Again, number 42.
42.
Other side is not there. We're making it not today only. We'll wait for them.
Again, number 43.
Not today, sir. Both. No one.
Again, number 44.
Shall we contested? Same.
Again, number 45. Again, number
45. 45. I don't know 45.
The other side is not there. We'll take it up tomorrow.
Lordship, in the last orders, like I have filed the affidavit in service and now. So the execution case is pending on. So that's why.
No, today you have a resolution. The bar has a resolution. That's why we are not.
Again, number 46.
Yes, Lordship. I honor the appellant.
Other side.
Lordship. In this case, there was direction to file a affidavit to talk to. We are not filing.
No. Right.
Main appeal maybe we are contesting. Want to contest the main appeal.
Yes.
Lordship, there is a delay, 479 days delay, Lordship. But at the first Lordship, judgment and award is passed by the landed court below Lordship. 18 in 14th
আরে
August
নিজে থেকে করো না,
2024, Lordship.
আমি বসবো তো থাকো এখানে। হ্যাঁ আমি উঠি না। Yes,
Award has been passed, Lordship, 14th August.
what is the reason for the delay?
Lordship, paragraph number 7 to 10, Lordship. Lordship, in the meantime, they prepared an appeal, Lordship, and thereafter they withdraw the appeal, Lordship. We have filed the cross appeal, Lordship. That cross appeal also withdraw, Lordship. Thereafter, Honorable Court has been directed to file a fresh, Lordship. We have filed this appeal, Lordship. I have annexed the order, Lordship, page number 8, Lordship. Annexer A1, Lordship.
No, in the COT was withdrawn, but it is recorded appellant submits. You are the respondent there.
No, Lordship, I am the appellant of the
No, appeal was
court,
filed
Lordship.
by us. Initially,
They-
we filed an appeal.
Cross objector is the respondent.
Yes,
Yes,
what was
You are
filed by
referred to
them.
as the appellant. That creates a difficult.
Yes.
Lordship,
Petition, appellant in the court.
COT is not an independent appeal. It's not a cross appeal. It's a cross objection.
cross appeal.
You remain the respondent in the appeal. It's recorded
Yes,
here as the
Lordship,
appeal.
Lordship.
Anyway, you submitted. You had filed the court.
Yes,
There
Lordship.
was a discrepancy in the factual discrepancy in the what? In your cross objection.
Yes, Lordship. And
And subsequently, we have withdrawn our, we have made payment and automatically we have withdrawn our appeal.
So therefore, we are allowing this. The reason for the delay, comma, as explained in the condonation application, comma, is that although initially the insurance company had preferred an appeal, comma, in connection with which a cross objection had been taken out by the present appellant, comma, subsequently the cross objection was withdrawn with the order dated February 17, 2026, with leave to file afresh. Push up. Simultaneously, comma, the appeal had also been withdrawn by the appellant stroke insurance company. Push up. Next para, upon hearing learned counsel, comma, this court finds sufficient cause for the delay having been explained. Accordingly, stop the accordingly. Can 1 of 2026 is allowed, thereby condoning the delay in preferring FMAT within bracket MV 29 of 2026. Yes. So will direct preparation of paper books or what?
Lordship.
Usual direction, paper books.
Lordship.
You are appearing for?
Another matter,
Shri
Lordship. Item number 30.
This is not yet over. What are you doing? The appellant shall prepare and file the requisite, in view of the appearance of the, you are for both the respondents.
No, no.
No, oh.
I'm for the insurance company.
Oh, the other
Insurance
respondent then has to be served. Acha, yes.
Respondent number.
In view of the appearance of
No,
the,
Lordship, they did not contest in the trial court, Lordship.
did not contest in the trial court.
Not
Well, in view of the appearance of the insurance company, stroke respondent number 1, comma, service of notice on the said company is dispensed with, on the said respondent is dispensed with. Fusab, it is pointed out by learned counsel for the appellant that the respondent number 2 herein, that is the owner, comma, did not contest the proceeding in the forum below, in the court below. Fusab, as such, comma, service of notice of the appeal on the respondent number 2 is also dispensed with. Fusab, the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Who shall leave it to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. Yes, you are mentioning.
List collapse, Lordship. Item number 38 was my matter, Lordship. It's a small CAN application I have filed for extension of deposit of stay amount.
Ms. Singh, since I have made it not today, if somebody was watching, they may not be there now.
That side is not appearing, the order. was-
Even then, since I have passed an order in open court, come back tomorrow, please. Yes,
Item number 47.
yes. Not today. Other side is not there.
Lordship, actually, in this matter, service has already been completed. And
That's why all the more necessary for the other side to be here.
not today, my lord.
Not today only.
Grateful, my lord.
Yes,
Number 48.
same, not today.
Item number 49.
All at any matter where both sides are there, otherwise your resolution comes in the way, or it can be taken up. All these are hearing matters. Most of the others. হ্যাঁ আচ্ছা পুরোটাই কল করে দাও দেখি যদি করে 50
50.
yes 50
My lordship, I am on behalf of the appellant insurance company.
other side has to be you have served
The
on the
appeal has been filed in due time.
so let us wait for one day tomorrow come back tomorrow you have a resolution today that's yes not today
Again, number 51.
call করে যাও not today যদি কেউ same
Again, number 53.
Item number 53. Mr. Mojumdar is the other side. He's some personal inconvenience. So he requested me to kindly fix on
Mr. Shukta Majumdar is appearing, my lord, in this matter. My lord,
So-
kindly fixed on the
Monday
Tuesday, my lord.
Tuesday first prop of the matter.
no talk
Lordship
not
can-
both pairs together Tuesday থাক ওই মানে next থাকবে হচ্ছে 16 16th the next time
Kindly Lordship can figure within 10 matters because of it.
no why
Lordship. Acha, please.
Again, number 54.
ডেকে যাও
55, 56, 57, 58, 59, 60, 61.
both sides present any matter
61.
both sides
61 lordship, I'm praying for a adjournment, my lord. For
Not today then.
2 days, 2 days. My lord, it's a
Why today?
preemption matter, my lord. I'll have to be prepared.
what do you say
2 days.
you are ready today what do you say to her
My
prayer
lord, today only I have received the brief.
day after tomorrow very well. day after tomorrow এটা পরশু দিন রেখো
63, 64 are same matters coming out from the.
you have called that
No, it's just
Well-
going to be called.
let it be called yes
62,
Yes, my lord.
not today
63.
63 64 similar matters
Yes.
so what do you want
So, my lord, I'm from the respondent. They have filed an application without condoning the delay from the trial suit to the High Court and
wait till
again
tomorrow
in
you are
in
Mr.
an
Ghosh
appeal.
you are Mr. Ghosh what is your name
I am for.
No, Ghosh is for the other-
respondent.
what is your name
Shatrudri Mukherjee.
Mr. Mukherjee wait till tomorrow you have a resolution today
Very well,
let,
my
let
lord.
them come tomorrow let us see
Very well, my
whatever
lord.
order yes
65.
Matter may
both sides are there move the matter
well, maybe fixed on next.
maybe but won't be you are ready both of you are ready why don't
Actually, I have had a word with Mr. Bhattacharya also.
that's
He's-
surreptitious that's collusive the court is not bound by it.
Actually.
when
Can it be taken
In-
up on next Wednesday?
Next Wednesday. my lord.
day after tomorrow or Wednesday
next
after next
week,
আছে very তাহলে 17th করে দেবে
Yes. It will
17th
take just 10 minutes maybe for your lordship.
10 minutes for me 10 for you each of you and yes very well 17th
We don't have any more energy left, my lord.
We have
Three
all-
honorable judges have heard it on multiple occasions.
Multiple
Could
occasions.
not finish it.
Could not complete.
so then the same fate will befall you if you postpone it till 17th
Monday may be done. Next
why Monday why not today
Okay.
আজকে হবে আমি ব্রিফ আনিনি
tomorrow come back tomorrow
well then day after tomorrow my lord.
why then how does it then come you are both of you are ready in all matters no come back tomorrow কালকে থাকবে list not today শুধু থাক
No,
come back tomorrow otherwise this will be the fourth bench
this will be the fourth bench.
you are responsible you are asking for 17th
No,
No,
actually,
my lord, we had
I was
a discussion.
we had a discussion
We
jointly.
were under the impression, to be very candid, my lord, that take your lordship more than half an hour to dispose it of.
Very simple.
no but why not that is not a reason for taking it up on 17th
My lord, I had requested him because
refused tomorrow not today yes
Grateful.
Item number 66.
you are appearing not today tell
67, my lord, day after.
very day after tomorrow
Item number 68.
My lord, there is one APMT matter.
Hmm.
It's on behalf of the appellant claimant.
Hmm.
The insurance company also filed another case, principal bench.
principal bench is it maintainable there
It's Court number 9.
how is it maintainable there this is which district
This is within the district of Malwa.
then
It's district Jalpaiguri.
so take a maintainability point there that has to be sent here
Actually, at the time, this appeal was filed in the year of 2019.
That time, the principal.
So what do you want? What is your prayer?
Here is, application, the appeal may be filed, transferred to the principal bench.
This court has jurisdiction, circuit bench has jurisdiction, that should be transferred here.
That, appeal case, insurance appeal case.
All pending matters also jurisdiction is now with the circuit bench.
So, that case may be transferred.
Pray for that. When that matter appears before the other bench, pray for that. It will be sent promptly here. We are just adjourning for the day. When is it scheduled to be held in the taken up in the principal bench?
Okay, that's, item number 41.
So let us wait for that. We will keep it next week. This matter is kept next week. So ask for a transfer of that to here. Now this bench, circuit bench, not my bench, circuit bench has determination to take up all matters regarding these districts.
This company has not been empty, but on the other side.
Take a point there. Go and take a point that is not maintainable there. It should be transferred here and mention there that this case is pending here. Call next. Not this week. There. Not this week. In the meantime, take steps there before the principal.
Item number 69.
Not today.
Item number 70.
Same.
71, 72, 73. All these matters are hearing matters.
Let us start. Both sides are obviously recorded. So that's why I'm making not today only.
Number 71, 72. Item number 73.
Same. Chalo.
75, 76. Hearing matter, addition of this, on this matter.
So what?
Can you be, the matter be fixed on 17? That is here, should be mandated to be present on the
17th. On the prayer of the appellant, the matter is adjourned till 17th, June 17, 2026.
Item number 77,
Not today.
78, 79 with 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90 with 91, 92, 99.
92, you want to move it?
This award has already been passed out. Subsequently, when we
Attainment of majority. Now you want to proceed in your own name. This application is for that.
the award has already this matter has been disposed of.
Suit has this appeal has been disposed of. देखिए file था. Appear कुछ जगह. Why is it appearing then in the list?
When we for this disbursement, at the time we come to know that already the petition number 2 has added the majority.
If the appeal is disposed of, then why are you? We don't understand. When was it disposed of?
That is disposed on 12 March 2025. And during the pendency of the suit, the applicant has added the majority.
So post fact after disposal of the appeal, what is the application for attainment of majority can only be filed in a pending appeal.
But at the time of the disbursement, the allotted register directed us to file a fresh application for inquiry.
How was it filed? The appeal was filed on your behalf by your mother or what?
At that time, she was a minor.
When did you attain majority? After the disposal of the appeal?
During the pendency of the appeal. Para number 3, she has attained the majority on 14 February 2024, as the award has been made on 12 March 2025.
That is your birth certificate.
Annex one other contact.
Nothing has been annexed to the application.
Yes, and
Where? I find only your vakalatnama. Nothing has been annexed. Nothing has been annexed. I'll a supplementary affidavit. I'm granting you leave. Annex the relevant documents to show your age. That will only be necessary. The present application has been filed in a disposal of appeal seeking to bring to the notice of the court that the applicant has attained majority during pendency of the appeal, comma, despite the same having been disposed of on March 12, 2025. Full stop, next para. However, comma, a perusal of the application indicates that no document in support of the age of the petitioner has been annexed thereto, full stop, in order to enable the petitioner to bring on record sufficient documents in that regard. Leave is granted to the petitioners to file a supplementary affidavit to Can 2 of 2026 within 1 week, within a week from date. Full stop, next para. The matter be listed next on June 17, 2026, under the same heading. You file your supplementary affidavit on the next day. If possible, give an intimation to the other side, the insurance company, whoever is there. Next.
93 with 94,
Same. No, not today.
95, 96 with 97, 98, 99, 100 with 101, 102, 103, 104, 105 with 106, 107 with 108, 109, 110, 111.
111, bring it to be placed in the next circuit. Now, difficulty is, my lord, I am not able to contact my client. Now, there was a direction to prepare paper book. Everything is ready, my lord, but I am not able to contact her.
On the prayer of learned counsel for the appellant, let the matter stand adjourned till the next circuit. Begin.